Honorable Speaker.
Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen. Amen. Namaste.
Oath or affirmation, announcements by the Speaker.
Honourable members, I have received communication from Mr. Barry Padarath, MP, member for Princestown, who has requested leave of absence from today's sitting of the House. The leave which the members seek is granted.
Bills brought from the Senate, petitions, papers.
Leader of the House.
Thank you, Madam Speaker. Madam Speaker, I have the honor to lay the following papers. Paper number 1, the ministerial response of the Ministry of National Security to the 12th report of the Joint Select Committee on Human Rights, Equality and Diversity on the sexual exploitation of children in Trinidad and Tobago, with specific focus on child prostitution and child pornography. Paper number 2, the ministerial response of the Ministry of Trade and Industry to the 23rd report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of InvestTT Limited for the years 2014 to 2017. Papers 3 and 4, the responses to this 27th report of the Public Accounts Committee on the examination of the expenditure and internal controls of the National Carnival Commission of Trinidad and Tobago for the years 2010 to 2018. The responses are from the Ministry of Community Development, Culture and the Arts and the Tobago House of Assembly. Thank you very kindly, Madam Speaker.
Reports from committees, Prime Minister's questions, urgent questions, questions on notice, questions for oral answer.
Leader of the House.
Thank you, Madam Speaker. Madam Speaker, there are 4 questions for oral answer, and we will be answering all 4 questions. There are no questions for written answer.
Member for Tabakeet.
Thank you, Madam Speaker. Question number 4 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, during the period October 2014 to 2019, PTSC purchased 97 buses as follows. December 2014, that were delivered in 2015, 35. February 2017, 2. April 2018, 35. August 2018, 25. Due for delivery in 2020. The annual total cost of the buses acquired above is as follows. December 2014, 40 million $689,000. February 2017, $1,020,000. April 2018, $34,403,000. August 2018, $29,543,000, and the grand total of $105,657,000. The current size of the PTSC fleet of buses is 336. From 2015 to date, 46 buses became unserviceable. There are currently 27 buses that are deemed not roadworthy and are undergoing short-term repairs. The buses stated above were deemed not roadworthy as follows: 18 buses, new defects, 5 buses deemed not roadworthy for 1 day, 2 buses deemed not roadworthy for 3 days, 2 buses deemed not roadworthy for 29 days. The current estimate indicate that PTS requires approximately 450 serviceable buses in order to provide adequate service in Trinidad and Tobago. However, this estimate is undergoing regular review based on supply and demand. I thank you.
Member for Tabaki.
Question number 5, the Minister of Finance.
Minister of Finance.
Thank you, Madam Speaker. Answer to Part A. The amount owed by CL Financial and its subsidiaries under the Memorandum of Understanding and the Shareholders Agreement is as follows. Injections into CLICO to protect traditional policyholders, $5 million and $5,000,095. Injections into British American to protect traditional policyholders, $872,322,077. Payments to CLICO STIPs, short-term investment products, $10,885,458. Payments to British American short-term investment products, $765 million. Sorry, let me go back, Madam Speaker, my apologies. Payments to CLICO short-term investment products, $10,885,458,001. Payments to British American short-term investment products, $765,065,063.
Minister of Finance.
So childish.
Minister of Finance.
Payments to
Minister of
CIP.
Finance.
Yes, I'm sorry, Madam Speaker.
Honorable members, I think we all want to hear the responses. So, I'd ask certain members to please remember their volumes and the low ceilings that we suffer from here. Minister of Finance.
Thank you, Madam Speaker. I think I better repeat. Injections into CLICO to protect traditional policyholders, $5,000,957. Injections into British American to protect traditional policyholders, $872,322,077. Payments to CLICO short-term investment products, $10,885,458,001. Payments to British American short-term investment products, $765,065,063. Payments to CIB depositors, $1,870,659,526. Payments to First Citizens Investment Services to protect CMMB, Caribbean Money Market Brokers, investors, $731,176,936. Payments to the liquidator of British American to acquire promissory note, $334,964,571. Interest and financing costs up to April 2016, $2,665,000, the numbers are so large, Madam Speaker, $740,710. Total, $23 billion owed by CL Financial and CLICO and its subsidiaries, $95,387,841. This figure, Madam Speaker, of approximately $23.1 billion does not include other costs such as advisor and legal fees incurred by the government. Of the total 23.1 billion, the debt owed to the government by CLICO was 18.085 billion, inclusive of interest of 2.229 billion. To date, the only member of the CL Financial Group that has repaid monies to the government is CLICO. As of September 30th, 2019, CLICO has repaid a total of 14,986 million, including interest in the amount of 2.159 billion. As of September 30th, 2019, the amount still outstanding by the CL Financial Group and its subsidiaries is 8,109 million plus legal fees, interest, and other costs, of which CLICO outstanding debt is 3,098 million, inclusive of interest to date.
The member for Tabakit.
Speaker. Mr. Minister, can you give an idea of how much money was spent as advisor and legal fees?
Minister of Finance.
Madam Speaker, I don't have that information, but it is a fraction of the money recovered. We recovered $15 billion, and the fees paid was an infinitesimal fraction of that amount.
Member for Tabakit, supplemental or?
Thank you, supplemental. Madam Speaker, of the $8 billion, $8.1 billion that is still owed, what are the prospects of collecting that $8.1 billion?
Minister of Finance.
Under the PNM, excellent. And it's 8 billion plus.
Member for Tabakit.
Question number 6 to the Minister of Education.
Minister of Education.
Thank you very much, Madam Speaker.
Big money.
Madam Speaker, the current number of teaching vacancies at the primary school level is 23. And at the secondary level, it is 229. The second part of the question, Madam Speaker, the annual number of vacancies filled at the primary and secondary schools from 2015 to date are as follows. In 2015, 202. In 2016, 107. In 2017, 219. In 2018, 151. And up to November 2019, 98. And that's for the primary schools. In the secondary schools, in 2015, 162. In 2016, 150. In 2017, 139. In 2018, 147. And up to November 2019, 176. Thank you.
Question, member for Chaguanas East.
Thank you very much, Madam Speaker. Honourable Minister, might you be able to advise us as to what year is currently being interviewed by the Teaching Service Commission for teachers to be appointed to fill these vacancies?
Minister of Education.
Madam Speaker, unfortunately, I am not in a position to answer that question. That is in the realm of the Teaching Service Commission.
Carney East.
Thank you, Honourable Minister. Would you by chance happen to have the breakdown in terms of denominational boards, in terms of the vacancies versus government schools?
Minister of Education.
Might not have.
Madam Speaker, in terms of the primary schools, the vacancies in the primary schools, yes, I can give that breakdown according to the boards, and I can give it to you now, Madam Speaker. Anglican Board, 3. It's 23. All those vacancies, I said there are 23 vacant positions in the primary schools, and all those vacancies sit in the denominational schools. That's okay with you? In the secondary schools, you would know there's a big difference. It is according to the subject areas. And most of the subject areas are in the technical vocational area where we are having some difficulty in attracting teachers. And I have a breakdown here which, again, I cannot give it according to the boards, but it's according to subjects. Okay? Thank you very much.
Supplemental member for Chaguanas East.
Thank you very much, Madam Speaker. Honourable Minister, given that you said that there's some of these interviews are in the realm of the Teaching Service Commission, as Minister of Education, are you satisfied with the number of persons who you are forwarding to the TSC to be interviewed to fill these positions from the Ministry of Education?
Minister of Education.
Madam, I am very happy to state that the Ministry of Education is doing all in its power to ensure that requests for the filling of vacancies that are made by this ministry to the Teaching Service Commission are done in a timely manner. And I'm very pleased to announce that. Thank you.
Supplemental member for Talakit.
Mr. Minister, can you tell us what is the average time it takes between when a person makes an application for a teaching position to the point at which the person actually gets a job? What is the average length of time is it taking to get a job in the teaching service, both at primary and at secondary school level?
I will note that as a supplemental question.
Good question.
Member for Chaguanas East.
Thank you, Madam Speaker. Question number 8 to the Minister of Labour and Small Enterprise Development.
Minister of Labour and Small Enterprise Development.
Thank you very much, Madam Speaker. I'm very happy to provide a response to the question as posed by the honourable member. Madam Speaker, official statistics of this nature are produced by the Central Statistical Office, popularly known as the CSO, and are available on either a quarterly or annual basis. The most recent data available from the CSO is the second quarter for 2018. So for the purpose of this question, Madam Speaker, I shall report for the period third quarter of 2015 to the second quarter of 2018, as it is the most appropriate in relation to the period I just mentioned. During the period of the third quarter of 2015 to the second quarter of 2018, CSO has advised that the following sector produced 12,500 new jobs, broken down as follows. Other agriculture, forestry, hunting, and fishing, 600 jobs. Other manufacturing, excluding sugar and oil, 2,400 jobs. Financing, insurance, real estate, and business services, 4,600 jobs. Community, social, and personal services, 4,900 jobs. It should also be noted that the most recent unemployment rate for Trinidad and Tobago that is available from the CSO, that is the second quarter of 2018, is 3.8%. This rate, Madam Speaker, is well below the international standard of 5% for full employment, thus confirming the sound economic management, good business practices, and progressive policy of the present government. I thank you, Madam Speaker.
Request for leave to move the adjournment of the House on definite matters of urgent public importance.
Member for Caroni East.
Madam Speaker. Madam Speaker, in accordance with Standing Order 17 of the House of Representatives, I hereby seek your leave to move the adjournment of the House for the purpose of discussing a definite matter of urgent public importance, namely the non-payment of outstanding sums of money to school bus drivers. The matter is definite because it pertains to financial arrears to more than 300 school bus drivers, some of whom are owed for several months and are unable to repay bank loans meet mortgages, and other commitments. The matter is urgent because the untenable state of affairs is seriously disrupting this vital service to the nation's children. The matter is of public importance because it affects the livelihoods of the school bus drivers and directly impacts the education of thousands of the country's school children. Thank you, Madam Speaker.
Honorable members, I am not satisfied that this matter qualifies under this standing order. Member for Caroni East.
Thank you, Madam Speaker. In accordance with Standing Order 17 of the House of Representatives, I hereby request your leave to move the adjournment of the House at its sitting today for the purpose of discussing the following definite matter of urgent public importance. Namely, the unprecedented breach of security at one of the country's public health institutions. The matter is definite because it relates to the murder of a patient at Ward 3 of Port of Spain General Hospital on November 26, 2019. The matter is urgent because newspaper reports have indicated that hospital staff are fearful and expecting further public assassination attempts at the hospital, while present ailing patients and visitors are experiencing serious trauma and panic. The matter is of public importance because such a crime, having been carried out at a public hospital, has placed the lives of all patients and employees at risk. Thank you, Madam Speaker.
Honorable members, I am not satisfied that this matter qualifies under this standing order.
Statements by ministers, personal explanations, introduction of bills.
Honorable members, I seek your leave for this matter to be deferred and to be taken later in today's business. Is this agreed? Yes. Proceed.
Motions relating to the business or sittings of the House and moved by a minister, public business, government business, bills second reading.
The Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a second time. Madam Speaker, we assemble today with Trinidad and Tobago's safety and well-being squarely in mind. Forgive me, Madam Speaker. Apparently there's a preceding point. May I? Yes. Madam Speaker, in accordance with Standing Order 122.1, I beg to move for the suspension of Standing Order 64.1a to permit the moving of the second reading of the Bill Amendment Number 2, Bill 2019. I apologize.
Honorable members, the question is that Standing Order 64.1a be suspended in order to permit the moving of the second reading of the Bill Amendment Number 2, Bill 2019. All in favor say aye. Aye. Any against? The ayes have it. Attorney General.
Madam Speaker, I now beg to move that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a second time. Madam Speaker, the Constitution of the Republic of Trinidad and Tobago is the supreme law, so enshrined in Section 2 of the Constitution, so stated expressly. We are permitted under the Constitution, under Section 53 of the Constitution, to make laws for the peace, order, and good governance of our society. This is the reason why two houses of Parliament assemble, consider laws as we do, and ultimately, within the separation of powers principle, we stand to state on behalf of the people whom we represent, particularly in this House, as opposed to those whom are appointed to debate. We stand to give the signal as to what our country requires, what is considered justified in a society such as Trinidad and Tobago, and we leave laws on the books of Trinidad and Tobago there to be interpreted by the judiciary and there to be operationalized by the executive in its various iterations, be they under the police, under the ministries with responsibility, security agencies, etc. The law which we bring today, having come from the Senate, having been passed without anyone in the Senate saying no to that law. In fact, 7 independents, 15 government members, all saying yes, and absolute silence from the opposition bench, each and every one of them abstaining on the law. We bring law now to affect 2 fundamental human rights. The first fundamental human right, of course, is to be found at Section 4 of the Constitution, and that is the right of an individual to life, liberty, security of the person, enjoyment of property, and the right not to be deprived thereof except by due process. And then, of course, in Section 5 of the Constitution, we look under the provision of the right to bail. Effectively, Madam Speaker, 5(2)(f) Roman 3, where someone ought not to be deprived when charged with a criminal offense of the right to reasonable bail without just cause. On the one hand, therefore, we have the whole of Trinidad and Tobago, each and every person under the Constitution looking for their right to liberty and enjoyment of life. And on the other hand, we look to consider the effect of the right to bail and not to be deprived thereof except without just cause. Today in The Guardian, front page, we see hospital hit, patient shot multiple times on Port of Spain, Ward 3. Gunmen dressed in CSI kits carry out killings. 25-year-old victim was admitted for stab wounds. Today, Madam Speaker, we see on the front page of another newspaper the position, this time, of the Daily Express. Mystery bomber, hundreds evacuated as explosive device detonated at Parkade. And today, quite simply, Madam Speaker, this bill, which appears to be short in its length, certainly, this bill treats with the very concepts that we're now addressing. 2 front-page newspapers finding themselves in Clause 3 of this bill, where we ask for the insertion of 2 things. 1, under the provisions of the Bail Act, Section 5, we ask for bail restrictions in the case of persons charged with offenses under Section 9A of the Firearms Act. Section 9A of the Firearms Act, which was recently introduced in August of this year, is the provision by which we establish for the first time an offense for trafficking in firearms. We also ask in Section 5 of the Bail Act for the inclusion of bail restrictions for possession of a prohibited weapon. We specifically, in Clause 3 of the bill, define what a prohibited weapon means. We say that it means artillery or automatic firearm, grenade, bomb, or other like missile. And, Madam Speaker, that Clause 3 of the bill coincides with the 2 front-page issues in today's papers. Could we have anticipated today in this House, as we come to debate this legislation, front page of Guardian, front page of Express, news in Trinidad and Tobago talking about bombs having been detonated, as is alleged, or devices having gone off, or automatic firearms having gone off? Perhaps, Madam Speaker, fate has a way of working its way out. So let's look, Madam Speaker, to what Trinidad and Tobago as a society is treating with. Madam Speaker, the evidence before us right now says, from the Crime and Problem Analysis Branch, and I'll just touch upon this, as I'm sure my colleague, the Minister of National Security, will give us deeper details. But I'd like to say that persons charged in the period 2009 to 2019, up to the 30th of June 2019, for the possession of firearms, we see on our books machine guns and submachine guns. And whereas for the period 2009 straight up to 2015, 2016, we had no submachine guns. In 2017, we have 23 persons charged. 2018, we have 14 people charged. 2019, as of June of this year, there have been more since, CAPA's analysis says 7 people, a total of 44 people. We also see for machine guns, Madam Speaker, in the same period, 2009 to 2019, that we've had 97 people charged for machine guns. Now, what is a machine gun? A machine gun, the weapon of choice these days, the AR-15, that is a weapon of war, Madam Speaker. And that weapon of war has been actually applied in Trinidad and Tobago with submachine and machine gun fire, killing and wounding persons, Madam Speaker. One weapon of war, a machine gun, within seconds can kill up to 50 people if it is unfortunate enough to be successful in the way it is applied. Madam Speaker, what we do know, that reports of firearms offenses in the period 2009 to 2019, we have a total of 17,908. We treat with murders 3,574 as at the same date referred to earlier. Woundings and shootings 2,911. Robberies with firearms 11,423. Madam Speaker, arrests for possession of firearms. In the same period, 2009 to 2019, we're looking at 5,900 arrests. Madam Speaker, arrests under the Anti-Gang Act. In the period 2011 to 2019, 213. I noticed the member for Naparima asking about anti-gang law being applied. Perhaps the honourable member, in my wrap-up, I will give him full details on that, but obviously he's not paying attention. Madam Speaker, when we take our positions forward into attempted murder, that is shootings and woundings, the figures again stand in staggering proportion. Madam Speaker, persons charged with crimes are one category of people. But, Madam Speaker, let's look to what the Trinidad and Tobago judiciary says and what the Trinidad and Tobago prisons says. Certainly, Madam Speaker, when we look to the judiciary tells us that we have a number of cases standing before the courts. And when we look to their figures, and we look at the magistracy in particular, if we look at the case types before the magistracy and matters pending, I'm taking last year's published figures, as at July 31st, 2018, when we look to arms and ammunition, we have 7,045 matters, Madam Speaker, standing before the magistrates' court. Madam Speaker, what we can say as well is that the number of convicted persons at the prisons, when we look under firearms, we're looking each year with a figure close to 100. For 2009 to 2019, each year the figures look as follows: 97, 81, 123, 97, 88, 91, 103, 147, 168, 196, Madam Speaker, and 49 and counting. This shows, Madam Speaker, that convictions for firearm offenses in our judicial progress through to prison for actual conviction shows that the number of persons who have been convicted have risen sharply, Madam Speaker, going from 97 in 2009 to nearly 200 in 2018. We've doubled those figures. Madam Speaker, when we look to the position of firearms, and we look to persons remanded, if we look at the persons remanded as at the 16th of May 2019, that is this year, albeit some couple months ago, For firearms, we have under the categories armed robberies, 212. Discharge of firearm, 1. Possession of ammunition, 94. Possession of firearms, 258. Shooting with intent, 24. Now, Madam Speaker, these are no small figures. This shows that there is an epidemic in Trinidad and Tobago, one which is not new, but one which has certainly climbed, Madam Speaker. Madam Speaker, if we look to the functionality of our Constitution, under sections 123, 123A of the Constitution, the Commissioner of Police is charged with the responsibility of managing the forces under his command. And when the Commissioner of Police steps out to indicate to the world that Trinidad and Tobago is required to equip the Trinidad and Tobago Police Service with a fighting chance by passing this law, I say to you, Madam Speaker, that we ought not to look at that position lightly. Madam Speaker, there are two speakers opposite me who continuously make reference to Singapore. One is Naparima, and one, Madam Speaker, is Chaguanas East. When we look at this position, Madam Speaker, I'd just like to put for the record that possession of a firearm in Singapore doesn't need to be treated with bail in the way we're treating with it. Possession of a firearm in Singapore, a conviction results in a hanging. The death penalty is prescribed for firearm possession. Firearm possession. We have a Commissioner of Police. We have Trinidad and Tobago under siege. We have Cuba North on a continuous basis talking about the persons in her constituency and the application of firearms, even on the seas. And yet the opposition says to this country that they are concerned to equip the policemen of this country with powder puffs. They are concerned to run a campaign of who cares. They are concerned to say that we ought to be afraid of something called framing and the exclusion of the judiciary, as they allege, from this law. So let me now turn to constitutional measures, to contemplation of the law. Let me remind that the Bail Act, which was born in 1994, which effectively did a codification of the common law, the Bail Act, as delivered under Keith Sobian, then Attorney General, specifically said that bail will be a condition for the judiciary to consider. It's stated at section 5.1 of the Bail Act, except in circumstances listed in the first schedule. And the first schedule is where you're looking at offenses that are capital offenses: murder, treason, hijacking, etc., where the death penalty can be applied. That section 5.1 of the Bail Act still stands undisturbed as the law. And I'm going to come to that in due course when I treat with what the judiciary has to say. Madam Speaker, the fact is that Trinidad and Tobago, in its constitutional arrangements under this law, the UNC, the opposition, is spreading fake news. They say to the country that the Bail Act is one which intrudes upon fundamental rights in a way that it ought not to. And Madam Speaker, let me put on the record, from 1994, we have had, on many occasions, the consideration of bail restrictions. In fact, Madam Speaker, today is the 17th time that we are seeking an amendment of the law. We amended the Bail Act in 2005 by Act number 19. Act number 32 of 2005, number 30 of 2006, number 10 of 2007, number 15 of 2007, number 25 of 2007, number 17 of 2008, number 9 of 2011, number 11 of 2011, number 12 of 2012, number 1 of 2014, number 7 of 2015. 5 times in the period that the UNC was in office, for 5 years and 3 months, we amended the Bail Act. And the UNC, the now opposition, in amending the Bail Act, Madam Speaker, saw Trinidad and Tobago effectively, especially under the Anti-Gang Act companion bail amendments, have people denied absolutely the right to bail on one charge under the Anti-Gang Act. Madam Speaker, if you go to the 2011 amendment and you look at Act number 9 of 2011, and you get to section 6 of that act, which amended section 5 of the Bail Act, listen to this. Subject to subsections 7 and 8, a court shall not grant bail to a person who is over the age of 18 years and charged with an offense under the Anti-Gang Act. Let me make this clear. The UNC, the opposition, passed law in 2011 with the support of the People's National Movement opposition, and on one charge coming before the court, no prior charges, no 2-strike, no 3-strike, on one charge coming before the court, sat down and operationalized law where you could have been framed. We did not, as a responsible opposition, come and argue that there was an unconstitutionality in this law. We put our hat and we put it on a peg that said Trinidad and Tobago comes first. In the UNC iterations of law in 2015, Section 5 was again amended to introduce the fact that if a police officer, if the prosecution informs the court that a weapon, a sidearm, a gun, any firearm was used in the course of the commission of an offense, that you shall be denied bail. Let me repeat that. Two real examples of the UNC saying the law ought to be applied so that we can actually have a fighting chance, Madam Speaker. One occasion, one charge, come before the court and no bail for you. Because, Madam Speaker, what the honorable members did then, and which we quite happily supported, we inserted into Trinidad and Tobago the ability for no bail, restrictions, 120 days, 1 year positions coming back. And I looked at the Hansard reports, and I want to single out today Chaguanas East, Tabaquite, Chaguanas West, then Attorney General Anand Ram Logan, every man Jack, joined by St. Augustine, the honorable member for St. Augustine, each and every one of them, in ensuring that the law was passed, said Trinidad and Tobago must take a strong stance. Madam Speaker, today, I want to put on the record, Act number 17 of 2019 is a radically different bail law in effect than what the UNC was operating with. Madam Speaker, even though we have never had a case in the Commonwealth which has yet tested at the Privy Council level the equivalent of our Section 13 of the Constitution and the reasonable justification argument, even though that is yet to come, and it will come very shortly, we said as an opposition then, and we say as government now, give Trinidad and Tobago a chance because it is okay for the judiciary to be instructed as to what Parliament would like considered within the confines of the operation of the separation of powers. In Act number 17 of 2019, we brought forward and we passed with the UNC kicking and screaming. Thankfully, the independent senators voted resoundingly in favor of the law, and they were compelled to support the law out of pure shame, Madam Speaker. But in Act number 17 of 2019, we introduced a very important concept. We introduced into Section 5 of the Bail Act a subsection 7A, capital A. And it says, notwithstanding subsection 3 and subsection 7, a person to whom those subsections apply may, in exceptional circumstances, make an application to court for bail. And we did that, Madam Speaker, because we specifically did not amend Section 5.1 of the Bail Act. And Section 5.1 of the Bail Act says, subject to subsection 2, a court may grant bail to any person charged with any offense other than an offense listed in Part 1 of the first schedule. That is, offenses for which you may suffer death as the penalty. Let me make this clear. Section 5(1) of the Bail Act, passed in 1994, has been left undisturbed by this government. We amended subsections 2, 3 in particular, 4, 5, 6, 7. We expressly added in subsection 5(7)(a) to say that you will always have the right to approach the court in exceptional circumstances. Today, we seek to amend subsection 3. We're saying in subsection 3, a court shall not, obviously subject to 7(a) and section 5(1), a court shall not issue the consideration of bail under section 6 of the Firearms Act, that's possession. If you come before the court with a charge and you have a charge for a firearm. Secondly, if you have a conviction and charge, we've treated with that in the bail amendments. And if you have a charge for a first schedule part 2, and you come with another charge for a first schedule part 2, that's serious offenses, you ought to have bail restrictions on you. But Madam Speaker, today in adding in trafficking in firearms and weapons of war as prohibited weapons, Madam Speaker, we are specifically saying to the world, to Trinidad and Tobago's court system, to the judiciary, we're saying to them that a court ought to be guided in not granting bail as an automatic, easy process. And we do so, Madam Speaker, because effectively in section 5(7)(a), which we introduced by Act number 17 of 2019, we say, notwithstanding 3 and 7, a person to whom those subsections apply may, in exceptional circumstances, make an application for bail. Now, Madam Speaker, I'm mindful that I'm being quite technical and legal, and I do so for the benefit of the Hansard in the event that this matter goes to court, so forgive me for being a little legalistic on this point. I'd love to speak in more basic terms. Perhaps I will in my wrap-up. But let me put this into context now. Madam Speaker, we did 2 things in modeling this law. Number 1, we looked at the UK experience. In particular, we looked at section 25 of the Criminal Justice Protection Order Act 1994 of the United Kingdom, which was amended after that law was struck down by the European Court. And secondly, Madam Speaker, we also looked at local jurisprudence in the combination of the Saint-Omer decision and the Justin Stuart Charles decision, and I'll come to those in a moment. Madam Speaker, what we did there in looking at the UK position is to say to the world that Trinidad and Tobago considers the wisdom of the European courts and also the UK courts. Now, Madam Speaker, there are 3 cases that are relevant to considering the constitutionality of this law. Ryan Reno Mahabir versus the Attorney General, CV 2015-03229, CV 2015-03475, Danielle Saint-Omer versus the AG, and CV 2016-00074, Justin Stuart Charles versus the Attorney General. In these cases, the attorneys at law for the defendants included Anand Ramlogan and Gerald Ramdean. These 2 persons participated in the UNC, one as Attorney General, one as a Senator, supported the passage of the 2015 law, supported the amendments in the period 2010 to 2015, and then promptly upon leaving the UNC office, went to court to challenge the constitutionality of the same law that they passed. They succeeded in the High Court, but they lost in the Court of Appeal. And it is the Court of Appeal decision that is very persuasive, because the Court of Appeal decision acknowledges what the UK Parliament did in its measures in supporting bail restriction. And I'd like to say that in causing the amendments to the Criminal Justice Protection Order Act, Lord Falconer's speech to the House of Lords effectively considered that there's a public interest and a primary concern in providing tough additional safeguards against bad bail decisions in these particularly serious crimes. The House of Lords recognized that the judiciary can get it wrong. But Madam Speaker, in recognizing that without interfering with the separation of powers, the legislature, this House, the Senate already having said yes, can give the judiciary guidelines, I'd like to put out the dicta coming from Mr. Justice of Appeal Gregory Smith in the St. Omer decision. And in particular, in that decision, I'd like to point out that the court recognized that in upholding the constitutionality of the 2015 law that Ram Logan and Ramdeen wanted to strike down once they got fired, once they were no longer in the UNC and they went to court to challenge the law that their own party passed and that they participated in, the Court of Appeal rejected their arguments, upheld that the 2015 amendments were lawful. That is where a prosecutor informs the court that you're in possession of a firearm and that you could have a no bail restriction consideration. In upholding the law that the Bail Act was not unconstitutional, and in making a particular distinction, Mr. Justice of Appeal Gregory Smith said the reason why he would uphold that law is because Section 5(1) of the Bail Act was not amended. It was not restricted. Let me put it on the record. Nowhere in our recent amendments, Act number 17 of 2019, nowhere in this bill do we ever touch or seek to touch Section 5(1) of the Bail Act. So the decision by Mr. Justice of Appeal Gregory Smith stands on all fours with what we're doing now. Constitutionality. Secondly, the Honorable Justice of Appeal relied squarely on the State of Mauritius versus Coriati, which is, of course, a very famous decision coming out of the Privy Council, and he relied upon the dicta of Lord Rogers and also Lord Mance. And I'd like to put this onto the record. I read now from page 19 of the judgment. And this is the Justice of Appeal quoting from the State of Mauritius case. He says at paragraph 30 of the judgment, Lord Rogers stated, I have come to the view that Section 2 of the 1994 Act did indeed purport to make a fundamental, albeit limited, change to this component of the democratic state envisaged by Section 1 of the Constitution. The crucial problem lies in the absolute nature of Section 5(3)(a). Where applicable, it would completely remove any power of the judge to consider the question of bail. However compelling the circumstances of any particular case might be. Now I want you to focus on this. The judge says, by contrast, a provision, for example, that persons of the type envisaged in that subsection should be admitted to bail, should not be admitted to bail unless in exceptional circumstances would not create same problems. Let me repeat that. By contrast, a provision, for example, that persons of the type envisaged in the subsection should not be admitted to bail unless in exceptional circumstances would not create the same problems, because the judges would still have a significant, even if more restricted, role in deciding questions of bail and the freedom of the individual. Madam Speaker, let me stick a pin. Let me go to the Bail Act. Let me go to Act number 17 of 2019, which amended the Bail Act. And let me put on record, again, for the sake of clarity, Section 5, subsection 7A, as it now stands on the record, which says, Madam Speaker, notwithstanding subsections 3 and 7, no person to whom those subsections apply may in exceptional circumstances make an application to the court for bail. We are therefore squarely maintaining the role and function of the judiciary, Madam Speaker. We are in no circumstances ousting the judiciary. We are therefore within the parameters of constitutionality. We are squarely aided by umpteen decisions coming from the European Court. In particular, Madam Speaker, when we look to the cases coming out of the European Chamber, and we look to the UK experience as well. We look to the case of R.O. versus Crown Court at Harrow, 2006, UK House of Lords, 42. When we look to Lord Brown's position there, when we look to the cases coming out of Canada in particular, when we look to the Trinidad and Tobago test of proportionality as well, Madam Speaker, we are within the boundaries of law. Now let's go to proportionality. In saying to the world that a judge ought to look twice at the issue of bail, a judge ought not to automatically grant bail, a judge ought to consider the circumstances of bail, if I can put it this way, with a jaundiced eye, the defendant always having the right to approach the court under Section 57A, we are saying, number one, that there is a legitimate aim to the law. What is the legitimate aim? The legitimate aim is to allow people a chance at liberty and safety under Section 4A of the Constitution. The legitimate aim is to say to people who have weapons of war and bombs and grenades that they ought to know that they will be at risk of having limited access to bail. The legitimate aim being such, we are justified in infringing or derogating from the rights under Section 4 and Section 5 of the Constitution. Secondly, is this legitimate aim and is this bill rationally connected? Obviously, there's a rational connection. We have demonstrated the statistical information which applies in this context. Submachine guns, firearms being found in our jurisdiction. Do we go any further than we ought to? The answer to that is no. In fact, we have distinguished ourselves from all bail laws prior. We maintain Section 5.1 of the Bail Act. We allow Section 5.7A of the Bail Act to exist. You can approach the court. Could Naparima just keep it down, Madam Speaker? Madam Speaker, we keep subsection 5.7A of the Bail Act. We allow the access to the court. Do we oust the jurisdiction of the court? No, we don't. Is that to be had? Is it now in keeping with the law as currently cast? Let's look to the Bail Act itself, Madam Speaker. The Bail Act, which is the law in Trinidad and Tobago, last amended by Act number 17 of 2019, is a very interesting piece of law. The Bail Act effectively has safeguards which act as safeguards in this particular law. Number one, there is a sunset clause that applies to this law. This law has a sunset clause. This law will come to an end in 2021 unless it is renewed. Number two, in the Bail Act, I want to point out that we have sections 9 of the Bail Act, 10 of the Bail Act, 11 and 11A. And what do those sections basically say? You go before a magistrate, both the prosecutor and defendant have the opportunity to make submissions. When you get before the magistrate, if there's going to be a denial to any of the parties, prosecution's case or defendant's case, the magistrate is compelled to put the reasons in writing, and you have the right of appeal to a judge in chambers. You get to the High Court. Either the prosecutor or defendant don't like the decision in the High Court, you have the right of appeal to the Court of Appeal. Sunset clause, magistrate, going to High Court, going to Court of Appeal. You know, that is, very simply put, Madam Speaker, that's called due process. Due process is the soothing remedy to constitutionality. Due process is what Baroness Hale, in her celebrated paragraph 58 of her decision in Surat, says requires you to feel comforted that not every Section 4 or Section 5 right requires a Section 13 exception. So, Madam Speaker, having put the law in thick context onto the record, let's talk to Trinidad and Tobago now. What will my friend from St. Augustine say today? Nothing. Here, point up here, nothing. What will my good friend from St. Augustine say today when he is on record in 2011, 2012, 2014, 2015, saying that the law then was constitutional. That one charge under the Anti-Gang Act where you could be framed was constitutional. Will my friend today recant his testimony on Hansard? Will Chaguanas East, who said the same thing in the Senate when he sat, who quotes for us Singapore on a daily basis, and he's my good friend and I have good regard and great regard for him, will he recant his testimony today? Will Tabakit, portrayed as an elder statesman today, recant his testimony to the people of Trinidad today?
No, none of them.
Madam Speaker, it cannot be the case that the 2015, 2014, 2013, 2011 amendments, where there was a complete ouster of the jurisdiction of the court, and where you could have been locked away on a charge simply under the Anti-Gang Act, where we are now in a different circumstance, where our circumstance is that we preserve Section 5(1) of the Bail Act. We allow the access to court in exceptional circumstances. I've just read from Lord Mance in the Coriati case saying that in the case where you preserve exceptional circumstances, that is a case of constitutionality. How do my learned friends today stand behind Siparia? Absent again. In the circumstances where Siparia says for her party, we will not support the Bail Amendment Act. Because we are concerned, according to Siparia, obviously a newfound concern that people will be framed. Because Siparia had no concern as Prime Minister when the Bail Act was being amended for the anti-gang charge. Siparia had no concern for a state of emergency. Siparia had no concern with a sidearm possession. Siparia had Commissioner Gary Griffith as the Minister of National Security, who sat in a cabinet, who said, let us put this forward as we should have in the amendments prior to 2015. We supported them in the PNM, Madam Speaker, because we are patriotic, Madam Speaker. We did not, when fired like Ram Logan or Ramdeen, rush to the court to bring a constitutional challenge on the same law that the UNC passed. Madam Speaker, there comes a point when you just have to have some shame. Some shame. Because, Madam Speaker, today is a day where this law, with the safeguards that are in possession, have to see the light of day. Today is a day where we need to draw a line in the war against crime. Today is a day when we need to recognize that when we did that collectively in the period 2006 to 2009 for anti-kidnapping, and we wrestled kidnapping for ransom down to zero, it was because of the operation of the bail restrictions, albeit in a law which is not the same law as this. That law, which died in 2016, was an ouster of the court's jurisdiction. Our court has a continuing jurisdiction. We do not offend the separation of powers principle, Madam Speaker. What will Barataria Sanwan say today? With the warriors in Barataria, does Naparima speak for you when he says nothing? Yes. Madam Speaker, the know-it-all of this parliament on the UNC bench is Naparima. Yes. Madam Speaker, I mean it in the sense of the person to contribute. But Madam Speaker, today is the day, Siparia absent, spokesman for the UNC says nobody will say anything. The Hansard record is there for everybody to see. Today is the day that the whip should be lifted. And today is the day that I challenge the leader of the opposition, if she ever bothers to turn up, to actually come and lift the whip and allow the conscience vote of parliamentarians to prevail. I know that St. Augustine will not be able to look at himself in a mirror if he keeps an inconsistent cadence. I know that Chaguanas West, that Sanwa Barataria, Chaguanas East will be in similar difficulty. Madam Speaker, this law is required. The opposition tells this country that the government needs to be hard on crime. The government is bringing legislation to deal with crime, not just because we think it's a good idea alone, but because the Commissioner of Police and the citizens of Trinidad and Tobago and 7 independent senators said so. And we do that as well, Madam Speaker, because not a single voice in the Senate said no, including all 6 UNC senators, Madam Speaker. Madam Speaker, when that vote was taken and every man Jack sat in the Senate, there were no voices saying no because a division was called. Every man put on his microphone. Every honorable senator as a woman put on her microphone. And nobody said no. Today, the population looks at the UNC. Today, the government looks to courage and support for good law coming from my colleagues opposite, and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a second time. Member for Oropuch East.
Thank you very much. Thank you very much, Madam Speaker, for the opportunity to contribute on what is a very brief bill before us, but one that should not be mistaken for something simple, but rather a very profound and possibly complex amendment, but very serious indeed, notwithstanding. It's a very brief bill with, might I add, about one serious provision in the bill. Madam Speaker, if some of us were a bit tired and a bit weary after several days of campaigning, the Attorney General did succeed in capturing our attention with what most of us on this side predicted to be the content of his presentation. Madam Speaker, when we met in caucus to have lengthy discussions on this matter, we predicted the approach of the government. We predicted the examples. We predicted the narrative. We predicted the approach. And so for us on this side, it is really match, set, game. Madam Speaker, the country has heard this narrative before. We are now in the 5th year of an administration, and the country has heard the narrative of the government that this is D-Day. Now, I thought Monday, December 2nd was D-Day, but today is D-Day. We will show courage and lift the whip and look in the mirror and all of that type of thing. Madam Speaker, today is a very important day, but this narrative is well known. And quite frankly, I don't think that the narrative will make any change in the national community. So people who believe one thing of the UNC and the opposition, that's how it is. Today there will be no marginal increase or decrease in nothing. Having said that, this is not a matter that we wish to politicize. This is not a matter that we simply wish to generate emotion and hysteria. This is a society where it is easy to generate emotion and hysteria. And I appeal to colleagues opposite, it is the wrong approach to use crime to fuel emotion, particularly when persons, all of us included, are victims or potential victims of criminal activity. A member of parliament in this very house, a few days ago, was indeed a victim of crime, and we are very happy and elated that things did not go as bad as it could, and he's safe and property recovered and so on. So, Madam Speaker, we ought not to politicize, we ought not to carry emotion and hysteria, but really make our cold case, make our arguments in a very sober and cold way without emotions and so on. Because you see, when you go in your 5th year, it cannot be that members opposite are now in a state of political desperation, that you speak with such emotion about, the war, weapons of war, and, you create this imagery that if today we do something, it helps so much. Over the years, we have heard so much of let's give the police a fighting chance. Every time we come with a bill to deal with crime, it is giving a fighting chance. We have given fighting chance once. We have given fighting chance twice. We have given fighting chance 3rd time. We have given, I think, 4 fighting chance, and today we call for another fighting chance. And we will give that chance. The opposition today is not inflexible on this bill. We do not want a situation where persons are walking around the place like Rambo with automatic weapons and submachine guns and grenade and missile and so on. That is not a situation that those of us in the opposition want to see. Not at all. So that we stand ready to support the government on harsh action that deal with that situation. Nobody wants persons to be walking around with a crocus bag of grenade. Nobody wants to see the type of weapons on display, killing persons, as leaders in the sector have said, hundreds of persons in seconds and so on. So we stand prepared to support the government on any law that deals with this crisis. Absolutely. We do. The job of the opposition is fundamentally different than that of the government. Absolutely. It is to raise issues of the rights of citizens. Yes. That's our fundamental job. The government is to make law. The opposition seldom, unless special majorities are needed, will participate in lawmaking in that way, by the numbers. But our job is always to stand in defense of citizens. And on previous occasions, today I challenge the government, what crime bill have you brought in 4 years that the opposition failed to support without proper debate, amendments where we need to, and so on? What? Is it FACTA? Is it anti-gang? Is it Bail 1, Bail 2? I can't remember offhand. I think there are several pieces of legislation that the government have come with, and 90% of them we have supported. Yes. Yes. Yes, it took time. It took time. It took some painful time. Discussing, negotiating, compromising. I remember in this house one night, we had to suspend debate and committee stage and so on, and huddle together both sides because we wanted to arrive at a consensus. And that is how we have worked with this government. This government has taken another approach which they are entitled to take. There's a sign I have somewhere along my property. It's a pirate sign. It goes, "The beatings will continue until morale improves." And the government approach was beat the opposition into submission. If you want to get their vote, beat them. Over the years, governments of the PNM and others took a different approach. We said, no, let's meet before. Under the former Prime Minister Manning, I know, under Mr. Pandey, under Mrs. Prasad Bisesa, the governments of that time, including Mr. Manning, when they come to the House with bills like these, they would meet the opposition before. Absolutely. A delegation from government, a delegation from opposition, tell us what are your problems, you have seen the bill, tell us. How can we compromise? How could we build consensus? If there's a fundamental problem, well, we know we can't support. But you know, Madam Speaker, major change in the laws governing the police in this country, in fighting crime, kidnapping for ransom, for example, came about because of the initiatives of a prime minister and opposition leader meeting before, discussing before. In these days of the administration of Diego Martin West, that is a old-fashioned approach. It is you come to Parliament and beat them into submission. And if they don't agree, we go to the population. So presumably if we don't have consensus by tonight, Piccadilly somewhere or some junction, the UNC, they're bad people, they support this, they support that, they don't want us deal with crime. while you could have solved all this problem with consensus dialogue. Madam Speaker, but I am forever optimistic that even today, we can reach compromise on this critical matter and bring it to an end where the rights of individuals are protected, but also the need to use force, serious state force, and aggression to deal with those elements are dealt with. So we satisfy two requirements. Madam Speaker, as the Attorney General pointed out, we are dealing with one bill today, but it has serious interlocking consequences and implications with three pieces of legislation: the Bill 1994, the Amendment number 17 of 2019, and today's the bill before us today. Madam Speaker, for better or for worse, the Amendment 17 2019, at that time I was prepared to contribute, but I was involuntarily debarred from doing so. So today I would like to, I welcome the occasion that I can speak and connect the two, as the Attorney General did. You see, Madam Speaker, the Attorney General loves the law. And no fault of his, he explained why he loves the law and went to give us some technical detail because he's preparing maybe for something else. And that is fine. But Madam Speaker, the law must be seen in its social milieu. It must be seen in its social, economic, and cultural context. It is not easy to take laws out of the United Kingdom, United States, Canada, anywhere, and just look at it and say, look, this is what they do there, it works. Or even Singapore. Look at what they do there, it works, and let us do it here. In Singapore, a minister came back to Singapore on a plane. He went abroad to dine or was received by a foreign businessman. They suspected he went to take a bribe. I think he was executed. If we do that in Trinidad and Tobago, we might not have a cabinet. Madam Speaker, what obtains in Singapore or the United Kingdom, United States of America, Canada, you cannot just transpose those things just so there's a cultural area that we operate in. There are institutions, there are colonial institutions of public administration that have functioned for decades in a certain culture with a certain, social psychology, so to speak. And I'll come to some of these issues now. Because on the face of it, what the government is doing, and Madam Speaker, it's not my intention to read word for word from the bill. Everybody read that already, and it's a short bill. What they're doing essentially is to pull two offenses: possession, trafficking in arms and ammunition, firearms and ammunition, and possession of prohibited weapons, which would be missiles and artillery and weapons of war and so on, and saying, look, if you are caught charged with these offenses, no bail. No bail. We're clear on that. But Madam Speaker, and this follows on the 17th of 2019 piece of law that came here and debated and passed, and unless I'm mistaken, Madam Speaker, this also offended the Constitution, and they got the support. The government at that time got the support of the opposition. It was only, I believe, a couple months ago, got the support of the opposition to pass this piece of legislation. I believe the opposition both in the Senate and in this House. And Madam Speaker, while I'm on that note, the Attorney General said, I think on two occasions, that nobody in the next place from the opposition bench voted against or said no. And there's a reason for that. That didn't happen by mistake. That wasn't accidental. In that there is a general agreement that the policy of a harsh and aggressive approach to dealing with elements in possession of prohibited weapons and trafficking in firearms and ammunition, that general policy is welcome. So we are not against that. So this is why the opposition in the other place took a calculated, deliberate decision not to vote against, but to abstain. Because we had no fundamental disagreement with an approach that says we must be tough. We had a fundamental disagreement with the government on protecting the rights of citizens. So there's a reason why you abstain and not vote against. Otherwise, you just sit down and say no. But when you do not have a fundamental disagreement with a policy approach, there's no need to vote against. But you abstain because you have a difficulty with provisions, particularly where it relates to the protection of individual rights. And that is a fundamental purpose for which we all care to. So 2017, now the Attorney General began, of course, by telling us that, you know, by fate, as it were, front page of the newspaper today, hospital hit. The hospital hit and made mention of that gunmen walk into the hospital, found a victim there, being treated for stab wounds and so on, and opened fire. Is it? A gunman. Sorry. Lavantil West, correct me, he says a gunman. And they opened fire, and there was a fatality. Then the Attorney General said, but we didn't know this would happen, of course. There was no need to, how do we know that? Look, an explosive device, what we suspect to be an explosive device, detonated at the government campus parkade. We didn't expect that either. But look how both of that fall into the two limbs of the offenses that we are considering today. Now, I am not, of course, going in any way to suggest that anything like that could have been pre-planned. I think that is completely bewildering. But it happens. But something else happened overnight. And Madam Speaker, we didn't plan that either. Because on page 5 of the Trinidad Guardian of today, alleged accuser in sworn affidavit, I never said cop choked, pull gun on me. This has serious repercussions, implications for what we are doing today. Madam Speaker, we didn't plan that either. But it happens, as the hospital and the parkade. And this involves the Commissioner of Police, and I'm coming back to it, because I think this is critical to our case here. So, Madam Speaker, the government is saying today, look, and we had crime data, we have the same crime data. There's no need to go and repeat the same crime data that the Attorney General outlined. I will say one thing in opening again, and it might be even controversial, is that one of the challenges of younger ministers and younger high officials of government, and maybe opposition, but government, is that when you are a young politician, particularly in extremely high office, you have not yet faced the brutality of injustice. You have not faced the brutality of injustice. So sometimes there's a way of looking at the world as if it is perfect, there is a paradise, we will make law and it will be faithfully adhered to. It is utopian in some way that, look, we can pass law, we can, what is it, getting it done, is that what they say? Get it out of the way, and things will work nice because we are going to give you good law, you will implement the good law, and things will work. And people are good generally, they are good people. You have not yet been bitten by the brutality of injustice, so you can come around to the Hobbesian view of society. Not yet. And some of us who are older in politics, not necessarily in life, we have faced some of this brutality, and Karen East here has faced a brutality that has shaped his framework.
Why I became bad.
And that explains why he turned beast. Because one day, Martin West said, I've known him for so much years, we ate together, we play football or whatever, cricket together, and when he joined the UNC, he turned beast. But he turned beast because he faced the brutality. In 2002. Of injustice. And today, I call on Karen East not to bring back that memory or to create unnecessary, pain, but to remind members of Parliament and the national community that we can all face this brutality. It is not Karen East alone. It is not Karen East alone. And our job, and I said this when I was in government several times, our job is to protect citizens from us. It's to protect citizens from the state and state institutions, that they may not fear law enforcement. They will not fear the prosecution system. They will not fear that they will be victimized or maliciously treated, and so on. That's our job.
Absolutely.
And then, and only then, when you have conquered that, you can bring law and look at it as the best law, and we will get through with it, it will work. But injustice is almost omnipresent in our business. So, Madam Speaker, I say that to get to my point now, and I want to cut to the chase because we don't have much time these days in speaking. There was a time we spoke for 75 minutes. We don't have that. what the government is saying to do in a nutshell is those two offenses, one pursuant, I believe, to Section 6 of the Firearms Act, that is the trafficking in firearms and ammunition, 2 or more weapons, and the possession of prohibited weapons, we define that. When you fall now, you are arrested, you are charged for those offenses, there's no bail. Now, someone is tempted to call this bill the plumber bill. The plumber bill. Because there's a famous or infamous occurrence over the past few days when a matter came up in the court and someone, a 19-year-old person, was found and sleeping in the backseat of a car, and the police, of course, conducted a search and so on and found components in speaker boxes in the backseat of in the trunk of the car. The person was taken to the court, and there was a certain persons revolted when bail was granted to say, well, that person is in possession. Well, in the criminal court, they make, I think, a distinction in practice with components and firearms, but the person is in possession of firearms and so on, ammunition, and they had the component parts. The person went to the court. It was felt that the person ought not to be provided to access bail in those circumstances. The Commissioner of Police made a statement, is on the record. The government, of course, made a statement. Now, at first glance, you felt, well, something is wrong with this plumber case. But, Madam Speaker, I have had, from a source I don't know, but I've had the benefit of reading some of the documents in that matter, Madam Speaker, and it's very instructive that the person was charged with possession of firearm and ammunition, which is already an offense under Part 2 of the Bail Amendment Bill pursuant to number 17 of 2019, of course. So the person had already, by virtue of being charged with an offense, was already listed. The person could have easily fell within the catchment of 17 of 19. But when they checked, of course, the person had no previous charge, the person had no charge pending, and no previous conviction, so slip out. But if this bill is passed today in the present form, the plumber may still access bail because it was not the charge for trafficking in firearms and ammunition or possession of prohibited weapon. The charge sheet is here. We have possession of the charge sheet and notes of the police officers and so on. It is all here. Plastic wraps. I won't read extensively, but where they found the items and so on. But the point I want to make from all these documents pertaining to the plumber case is that if this bill is passed today in its present form, that person could still access bail because that person fell not under this matter, but under the already established number 17 of 2019, but had no pending charge and no previous conviction. So this is not a recipe for solving that problem, Madam Speaker. Madam Speaker, the other related matter is that you are introducing now the government, and I humbly and respectfully make a submission now, and I ask colleagues opposite if they would, without emotion and hysteria, respond to this argument. The government is taking a policy U-turn. There's a policy contradiction in the approach to bail. If it is in August, number 17 of 19, you provided that for the listed offenses on Part 2 of the schedule of the Bail Act, you cannot access bail. And I am not on the constitutional issue. The Attorney General has spoken on it. I think other colleagues will speak to that. So I'm not on the constitutional issue. I'm on this issue. If on number 17 of 2019 you have said that the government made an amendment, I believe in the other place, that a person now will be denied bail or cannot access bail if they have a pending charge or a conviction. So again, a first-time offender, so to speak, although it's not the correct term, a first-time offender would be outside as the plumber got out. Correct? But that was the policy position of the government a few days ago. But today, it appears that the policy, there's a policy U-turn, a policy contradiction, to suggest, Madam Speaker, that, hold on, you see, for now, trafficking in firearms and ammunition, possession of a prohibited weapon, we're not taking that so. First-time offender or not, having charge before the court or not, you're going to jail. 120 days. If your matter starts, now if your matter don't start, as the Attorney General like to say, it is lucidly clear that you knock on the door of the courthouse, you apply for bail. However, if your matter starts on the 119th day, well then no bail. You continue to stay in jail. But this is for the first-time offender who has no charge pending, who has no conviction, charged with trafficking in firearms, and charged with possession of prohibited weapons. So there's a policy you change. Why don't you just remain faithful to your August 2019 policy position, and we end the talk now? Put the same thing you did in August, put it in November, and say, look, we are consistent in our policy sense. We're coming with the same thing. There are 2 new offenses we want to raffine under Part 2 now, but we will just include that and say, and this is what the opposition is calling for. And I intend today, at an appropriate time, I intend to table an amendment to that effect. So that persons who are, for the first time, they have no charge pending, they have no conviction on any of those Part 2 offenses, can access bail. But that doesn't mean it is automatic even then. There are circumstances in which you may not get bail, even though the law provides that you can access it. The jurisdiction of the court. Yeah. The other matter is on that Plummer case, it was very instructive, and correct me if I am wrong. When bail was granted, the police, subject to Section 11 of the Bail Act, the prosecution, police, DPP, and so on, they could have appealed to the High Court to deny bail or change circumstances or something, conditions, but they did not. Now, why did the police or the DPP did not appeal the decision in the Plummer case? Is it because they knew that they had no convincing argument, so it makes no sense going to the High Court to appeal? But the government comes with this draconian measure, speaking in emotional terms of the war on crime and carrying around Rambo-like weapons and how much damage it could do, to tell us we need this and give the police a fighting chance. We gave them fighting chance 4 times, and they are fighting. But I would tell you, Madam Speaker, this is not an electoral issue. I want to tell you something. Whatever happened today in this Parliament, it changed not a vote on Monday, December 2nd. So don't even go there. Madam Speaker, I had the privilege on Sunday to drive through some parts of Labre in strong PNM areas, and I was shocked at the welcome the UNC received there. I was personally shocked. We were so well received and embraced. I couldn't believe it. But Madam Speaker, now is not the time for that. Madam Speaker, so Labre, please. Madam Speaker, the outgoing member for Labre is harassing me. Madam Speaker, to come back to this point now, the government could take the same position they did in August. Why not? Because there is so much room for abuse. Madam Speaker, I come back to the article I read a few moments ago. Before going in history, let's get to the issue of the day. This is a matter in which a front-page story in the Sunday Express, I believe, spoke in blaring headline that the Commissioner of Police, no less a person, choked someone and put a gun to their head. This is the Commissioner of Police. Front page of the Express newspaper, which is a popular and well-circulated newspaper internationally. When persons read that all over the world, what is their impression of this country? And Madam Speaker, today, the person who is purported to have made that statement is saying today in the newspaper, that is not true at all. That is not true at all. In fact, the person is saying that no such thing happened. And the person is saying, has done an affidavit, sworn affidavit, denying this ever transpired, and has gone so far as claiming there is a committee consisting of police officers and media personnel operating to take down the Commissioner of Police. That is in the newspaper today I'm reading. Could you imagine that? The Commissioner Griffith is responding by saying, and I quote him, "I am not surprised. I have stepped on many big toes. It has been a few months now that there have been an orchestrated attempt to use certain individuals, rogue elements in uniform, and one or two individuals in the media to deliberately undermine the TTPS and the performance of our duties because we have been hurting big illegal business, unquote. Now, Madam Speaker, if police officers, as the police commissioner is suggesting, can set up and frame, attempt to set up and attempt to frame the commissioner of police, but who is we? Let us be real. Who are we in the whole scheme of things that you can come to someone home? Let me give you practical examples and throw 2 weapons over the fence, throw some spent shells over the fence, and when they raid, they come the next morning and raid, you go down. You have not one charge before the court. You have no charge, you have no conviction. So you are there resting, you know, resting in your winter years, Arima, and some malicious and vindictive soul come to that fence, probably angry that the school wasn't completed, and they throw some device resembling a grenade in the yard. They take down the poor member for Arima and have him for 120 days in jail, waiting with the possibility of more if the matter is not started in that time. What kind of legislation is that? And the whole family, not just the member for Arima hypothetically, but the whole family go. Madam Speaker, we grew up in a culture, I'm coming to Sadiq Bash in a minute, we grew up in a culture where when you go in the market, you go down in the market to pick up someone, they just make their market, or if they are wholesaling, they will have several bags.
Your original speaking time is now spent in title 15 minutes. Please proceed.
Yeah, just so, Madam Speaker, we come from a culture where people go in the market, if they're wholesaling, they buy 10, 12 bags and so on. When the taxi pull up, they tell the taxi, pull the trunk. They pull the trunk and you put the 5 crocus bag and the market basket and so on inside. They say, let's go. Now taxi drivers and PH drivers, because they exist, don't come outside and frisk the bag and search the bag and put the crocus bag through a metal detector test. Sometimes in the community, they don't even know the name of people. They call them by a nickname. You don't even know their real name. You might have an idea where they live in because you dropped them by the junction of a trace, but you don't know their name. Madam Speaker, they put something in the trunk of the car you're driving. Police, they have a roadblock coming up there. The fella jump out the back seat. When he see police, he jump out and run in the bush. Taxi driver reaches, says, sir, what is the problem? License insurance. Open your trunk. Mr. Taxi driver, with no matter before the court pending, no conviction, goes to jail for 120 days plus. No bail. What law are you passing today? I asked the government, members, I joined the Attorney General and I asked you to look in the mirror. Look at yourself. Look at yourself. Think of your family. Think of your children, grandchildren in some cases, Arima. Think of them. If they become the victim of this, it will not be you. You don't do it. You are not the culprit. You are not the criminal. There are others. The Commissioner of Police has alerted us that there are rogues in uniform. Madam Speaker, Sadiq Baksha, former member of Parliament here. One morning they found missiles and narcotics in a water tank. Mr. Baksha and his entire family under this law would be in jail for 120 days plus no bail. Is that the society you want to create? Because, you know, the Attorney General, with all good intentions, believes that he's implementing the law. He's not. The Attorney General is making law, not implementing law. The Attorney General cannot speak for the sergeant, the constable. And I want to make another point. I've interacted over the years with many police officers on the right side of the law. And, Madam Speaker, police don't trust police in this country. If a police is suspended and you ask the police, who you want to investigate here? Police in Trinidad or Scotland Yard? This is Scotland Yard, please. They don't trust. In a real case that I know of, a policeman is before the court in San Fernando, suspended and has a matter before the court. The policeman reports that the virtual complainant asked him one day when the matter was finally dismissed, after 2 years going to court. The virtual complainant told him, real case, he said, what these police officers have with you? Why they put you through that? And that is the issue. The Gomartin Northwest is suggesting that is foolishness. But it's foolishness for him because he comes from a privileged background with a boat, with a mansion. He believes he's protected from the injustice of the society. Madam Speaker, I share the view of that chairman in the Gomartin. The other night, I shared that view. Madam Speaker. So, Madam Speaker, today, all I raise with the government is that if you can tell us how are we going to prevent this abuse that the Commissioner of Police is speaking about, no less a person, that we have examples of. And Madam Speaker, and they're real, they're the subject of court decisions. Madam Speaker, I have before me a document. Madam Speaker, I have before me documents where in matters, and I'll just give you one example. In the Guardian newspaper of the 14th of December 2016, headline, siblings freed as police fabricate evidence. The Guardian newspaper now. Magistrate Raghunanan said she believed their claims, the police officer claims. She found, and she did not believe the police officers and found the persons not guilty. Madam Speaker, it is said in that matter that the police officers could not be believed. You couldn't believe them. Madam Speaker, in another matter, when the state lose appeal and so on, judges regularly make comments about fabricating evidence, planting evidence. Madam Speaker, in a matter of Anisha Rafiq versus the Attorney General of Trinidad and Tobago, Madam Speaker, 2017-01077, page 75 of the judgment by Justice Margaret Mohammed. She said, and I quote, Madam Speaker, the allegation of fabrication and planting of evidence by police officers is a serious matter. I am satisfied that there was a cogent and compelling evidence that the plastic bag, whatever containing cocaine, was planted by the police officers who searched the middle bedroom since they had the opportunity to do so, as no occupant from the house was present during the search of that bedroom. This isn't a judgment. Police officers in Trinidad and Tobago, Madam Speaker, it happens all the time. We could get plenty case and quote. But how can you therefore pass this law which contradicts your August policy decision, contradicts the policy decision August, and say, listen, for these two things now, these two offenses, absolutely no bail.
3 months later.
The police commissioner has raised an important issue, Madam Speaker. We call for a full and complete investigation into any purported attempt to frame and set up the Commissioner of Police in this matter. Nothing else will suffice. Because you cannot run a service where the police commissioner now need to look behind his back, look cocky-eye at every police station in the country, if for one reason or another, discipline or otherwise, he transfers an officer. He has to look behind his back now. The police officer cannot go in 54 police station and read the station diary. And Madam Speaker, this is the, as I said before, this is the social, cultural environment in which we operate. So what is our request? Is our request heartless? Nope. Is our request so callous, reckless, unreasonable, that we ask you to use the same policy frame you used a few weeks ago in August, and just set it now in motion that persons who are charged for the two offenses that we speak here today will be denied bail if they have a pending charge related under Part 2, Schedule 2 of the Bail Act, if they have a charge before the court or if they have a conviction. In the last 10 years or so, there's another formula for that. Madam Speaker, what is so reckless and unreasonable about that? Is it that the government is so adamant, so arrogant in some cases that, listen, we don't want that. We don't want that. Madam Speaker, we don't want that. We don't care about that. Because you see, the victims are people out there in the society who some of you may know. You may or may not be a victim, but the victims will be outside. And I want to leave the population with this notion that while, yes, we can trust and we have faith in I think the mass majority of police officers, there are still problems with the police service that the commissioner and others in law enforcement are tackling to clean up the police service, whether it's dealing with guns, dealing with narcotics, dealing with all types of things. Rogue elements. So, Madam Speaker, the government spokesman, I would advise you, Instead of giving us a nice long lecture on the emotions of crime and how much and what is a Uzi and what is a submachine gun and how much hundreds could be killed in 2 seconds and so on, tell us why you just cannot accept this one amendment that we will raise here and let us pass the bill. Let us in all good conscience pass this bill, get it over with. Because I will indicate, Madam Speaker, in case they forgot, it is not automatic that you get bail even if they put in this amendment. You can go to the court and the court will have other considerations. And you can appeal. Section 11 of the Bail Act allows for an appeal. To change, for a change, a fundamental change, Madam Speaker, there is no need for this draconian step at this time. And I know the speakers opposite will come with all their data. I have the data in front of me, Madam Speaker, submachine gun data and so on. We received that piece of information. Submachine gun for the years 2009, 000 coming up the road. By 2017, 23 submachine gun seized, 14 in 2018, and 6, I believe, so far this year. We have the same information. Madam Speaker, how many persons there, when arrested, when charged, would simply fall into the category which a new amendment will bring, and you will still have them in custody? Because the government agrees with the opposition on another point, that bail is not a punishment. Bail has never been meant to be a punishment. It is meant to present you to the court, and in other circumstances, you consider the seriousness of the offense, other matters, and so on. So it is really to ensure that you surrender yourself to custody, and you come to court. It is to ensure that you pose no threat to someone outside. You will not interfere with a witness, for example. You will not breach some other law, Madam Speaker. So, and the law already has set up caters for that. And there's a room for appeal on these matters if you feel that a decision is so perverse. What is shocking about the Plummer case is everybody says a perverse decision, nobody appeal. Nobody appeal. That's perverse in its So every time these things happen, we condemn, but we never appeal. So, Madam Speaker, that's like saying, the last ball was clear LBW, but we didn't appeal. You appeal if you believe something has gone wrong. You ask for the third umpire. You ask for the third umpire if you believe that you are right. But in that matter, there was no recourse to the third umpire. Presumably because we felt that the decision was not as perverse as portrayed, Madam Speaker. So, the Commissioner, the government, and the opposition are on one side in this debate. We are on one side. Deal with people who are up to no good. Deal with those who are up to no good. Because you cannot be walking around with submachine gun. You cannot be walking around with 2 grenades in your back pockets. You cannot be walking around with artillery for war, and you're up to good. No. Well, what, you're going to exhibit in a bazaar? You cannot be walking around with that type of thing for any good purpose. Once you are doing that, you're up to no good. And even for a first-time offender, if you put the amendment we are suggesting, there is no automatic guarantee that they will get bail. But what you have done is you would protect the innocent. Yeah. And Madam Speaker, as hard as it sounds, there's a maxim, there's a belief, there's a principle in our criminal justice system that if 1 person out of 100, 1% is innocent, it is too much that you have incarcerated and condemned 1 person out of 100 that you have done wrong, although the 99 are guilty as sin, Madam Speaker. And the opposition is purpose today is to raise this matter. It is not my intention to frighten anyone, to frighten members of the House, to frighten members of the national community. My intention was always to give a realistic perspective on what happens in our society. And the Attorney General will mean good. Members of the government, notwithstanding we spar and we trade punches and so on, they're in public office. The presumption is that they mean good. They want to deal with a problem. But you cannot undermine the rights of citizens in this way. Subject them to brutality and injustice and say, okay, if you are treated badly, when you come out of jail in 4 or 5 years, you'll go to the High Court and sue the police and sue the Attorney General. And one day you'll end up with $500,000 after you spend 7 years in jail. It cannot be the solution. Absolutely. It cannot be. You know how much money? I didn't even call that. I have the data. How much money the state has had to pay over the years, Madam Speaker, for police officers who violate the law, protocol. How much money is that we have had to pay taxpayers? And this is a matter that is receiving the attention of the Commissioner in the Police Manpower Program for Change, but it will not happen overnight. It will not happen overnight. So, Madam Speaker, I think that's it. In closing, it is not necessary to have a long debate. It is not necessary to stay here till midnight. Those of us on this side have some purposeful campaigning to do. I note, Madam Speaker, that colleagues on the other side are not required on the campaign platform. And had I been, Diego Martin West, I would know why we don't want them on the platform, so that they can stay here all night. They can sit here all night. But, Madam Speaker, this doesn't require a marathon session. It requires reasonableness. It requires, thought, consideration, protecting individuals while snatching those demons with all those weapons and artillery of war. While snatching them, one way or another, snatching them, it requires a little reasonable approach. And we are prepared to talk, to negotiate, to build consensus on our amendment. And, Madam Speaker, I will leave the government with those few words.
Thank you very much, Madam Speaker. Madam Speaker, I sat here with interest and listened for the last 45 minutes as I heard certain key tones and key words be thrown out to try and grab the public attention while creating some sense of murky water, if I may use that term. The truth is, Madam Speaker, Trinidad and Tobago is facing very difficult times when it comes to crime. Crime is one of the main issues affecting Trinidad and Tobago today and has been for the past few decades. And I want to put on the record here, Madam Speaker, at the outset, as I've said repeatedly in my last few contributions, all the 41 of us in this House, elected members, can do while sitting here carrying out our duties is pass legislation. That is all that we can do. And hopefully, on every single occasion, regardless of the side of the House that we sit on, we all have one aim, which is the aim of passing good legislation for the people of Trinidad and Tobago. And if there's a single person elected in here who does not have that as his or her main purpose when they come here at every sitting of the House, representing our various constituencies, then I'd like to suggest something is wrong. To start by saying that the government has changed its policy, as though when you make a policy, it is a policy set in stone, and no government should change its policy, is hypocrisy at the highest level. Because we heard the Honorable Attorney General, the member for San Fernando West, tell us that not too long ago, when those on that side sat in the seats of government, they passed the same law, which one can argue was even more draconian at a time, and denied persons bail for sidearms. Denied persons bail without any previous conviction or previous charge for a mere sidearm. Madam Speaker, I would like to assure the population of Trinidad and Tobago and the citizens and the people that the heads of the various divisions of national security and myself are working tirelessly and continuously to fight crime and the criminal elements. And I use this opportunity at the outset to thank the men and women of the Trinidad and Tobago Police Service, the Defense Force, our Prison Service, the Fire Service, Immigration, and our Intelligence Services for the yeoman's duty that they are doing by putting their lives at risk on a daily basis. And I make that point to let the population know the reason the government has come here between August and November with a change in policy in a very limited way, and I'll come to that. Because you listen to the leader of the opposition, who is a member of the inner bar and someone who should interpret the law and know the law and be able to profess on the law. Unfortunately misleading. And even some of what my friend from Oropuchi said here today misleads to an extent. But I will clear it up, and I'm sure he had no intention to mislead the House or the population as to what the effects of this bill are and how narrow the circumstances and the parameters of this bill are. So I started off by saying that the men and the women of the various heads and divisions, including, most importantly, the police service, are the ones who are putting their lives at risk. And the reason for the policy change between August and now is because the police service, the same police service that the member for Oropuch East is very, very cautious not to criticize. And he said, and he's placed it on the answer, that he supports the Commissioner of Police and the police service. It is the police service who've made this request. It is the police service who have asked and recommended we make this simple amendment, because it is a simple amendment. Crime changes, criminal activity changes, it morphs. What we faced 2 decades ago, we don't face now. 2 decades ago, the availability of automatic firearms was a non-existence. 2 decades ago, the police service and us, the citizens of Trinidad and Tobago, did not face the possibility of going out there and being confronted by persons with automatic firearms. It simply did not exist. 2 decades ago, what we were facing on the streets, at best, was a semi-automatic handgun. The vast majority were all revolvers with a few rounds. Yeah. Every single week now, as much as they try to trivialize it, every single week now, Madam Speaker, we face the reality of AK-47s and AR-15s, and we cannot trivialize that.
And they know.
Because, Madam Speaker, one AR-15, one AK-47, and every time we find these perpetrators, they have more than one magazine, and every magazine is full to the tilt. I remind people a few weeks ago, when we were facing this in the other place, the live example on that day was we had picked up the night before 3 persons, 2 dressed in police uniform, with an AR-15 with 2 full magazines, so that's over 60 rounds of bullets, bigger than your finger, as well as a Glock handgun, which I've said repeatedly is a sophisticated handgun. That is what they had, dressed in police uniform with another person. And driving a vehicle with blue lights. That is what we're facing. That is the reality of what we're facing. It's nothing to do about passion and emotion. Passion and emotion are a good thing if you're doing it for the people of Trinidad and Tobago. And that is what we're here today about, all 41 of us. Today, unfortunately, once again, we're faced with this. During the period of time, over the last 2 months, we have had, he calls it, the member for Oropuch East calls it the plumber case. Again, in his typical style and fashion, trivializing it. 9 AR-15s, whether a man sleeping in a car, awake in a car, on his feet, whatever. I put to the people of Trinidad and Tobago, through you, Madam Speaker, which person engaged in legitimate activity would have in their possession or have any lawful excuse whatsoever to have one AR-15, which is a machine gun. Yes, it is a tool of war, much less 9 of them. Regardless of how a police prosecutor relays his charge and drafts his charge in components and parts, because the criminal element is a sophisticated one. And they're not standing by with their AR-15s all assembled when they're transporting it. They're not stupid. They know how to break down these weapons of war and carry them in components to try and avoid the charge and being faced when caught with 9 AR-15s. Less than 2 weeks later, we then picked up in the 4 Roads jurisdiction 8 AR-15s. 9 plus 8, 17 AR-15s. A special forces team is normally in a composition of between 6 to 10. That could have outfitted 2 special forces teams. And this is the reality, Madam Speaker, of what we're facing. It's not hypothetical. We're not here in this House today changing policy because we wish to. It is because it is necessary. Absolutely. It is absolutely necessary that the 41 of us here today pass this legislation in its current form without change. I want to tell the people of Trinidad and Tobago through you, Madam Speaker, all this bill is doing is stopping persons in the first instance. They don't have a prior conviction, they don't have a prior charge, and I'll come to why we went that way, who have in their possession artillery. When I mentioned this to some young people, what this bill is about, they said artillery. Even the young people know artillery is a term of war. So this is to prevent any person from having in their possession artillery, automatic firearms, not sidearms, not a handgun, not even a shotgun, automatic firearms. And by the way, a Glock can be changed into an automatic firearm by just changing one component in it. And every time we pick up the criminal element with Glocks today, they have what we call an extended magazine that can hold 33 rounds. I guarantee you, Madam Speaker, anyone in this House today, including the men and women in the Trinidad and Tobago Police Service, any one of us today who faces the barrel of a firearm will not make any distinguishing argument as to whether it is a handgun, a sidearm, or a weapon of war, an AR-15, or worse yet, an AK-47. But they are out there. The reality is these are the weapons now being used by the criminal element. So all this bill is doing is saying anyone found in possession of artillery, automatic firearms, a grenade, a bomb, or other missile, no bail for you for 120 days. And I ask any single member of this House, including those absent, for example, the leader of the opposition who has senior counsel status, to stand and tell any right-thinking citizen in Trinidad and Tobago, any civic-minded citizen in Trinidad and Tobago, that it is okay for a person to have an automatic firearm and a grenade in their possession. And then on the first day and occasion they appear in court charged with that offense, they should be back out on the street the next day. So the person caught with the 8 AR-15s and the 9 AR-15s goes to court because to have that level of sophisticated weaponry at your disposal, you are going to be able to raise the money for bail. The person with the $500,000 bail got the bail and is out. And the next day he comes and he stands up next to you. Any one of us here in this House, or any citizen of Trinidad and Tobago who's a legitimate citizen, a law-abiding citizen, will they feel comfortable the next day, a person who the day before was found with an automatic firearm and a hand grenade is standing next to them in the same proverbial bus that they talk about? And then nice words, by Oropuch East at the end, talking about I didn't come here to create any fear. Quite the contrary. The typical strategy is the fear-mongering. The typical strategy is to try and reach the citizens out there and say, this is a draconian piece of legislation, Spend a lot of time about framing and setting people up, and the police and the commissioner of police is talking about police setting him up. That is applicable to any single criminal offense. Every single criminal offense. What stops a police officer from setting any one of us up with murder? And there's no 120 days to get bail in murder. Because once you're charged for murder, until the matter is determined, you have no bail. So that is a fallacy of an argument. It is a ridiculous argument to make. It just makes no sense. You cannot oppose criminal legislation or law to deal with criminality on the basis of saying the police could set you up. Because the police could set you up for anything. Including murder, as I just said, where there is no bail. So come with another example, come with another reason, but you can't fool the people of Trinidad and Tobago. So, Madam Speaker, the first point for people to understand is this is a very narrow restriction of your right to bail. if you have an automatic firearm, if you have artillery, a hand grenade, a bomb, or another device like that. Which sensible person in Trinidad and Tobago will accept that anybody should have any one of those items in your possession? And you know what? You know what was left out? You know what was left out? Section 7A, which we passed in this House not too long ago, in the same August time. Section 7A of the Bail Act. Section 5, subsection 7A, that says that a person to whom those subsections apply, which will include this, may in exceptional circumstances make an application to court for bail. So what we haven't been told, be it by the leader of the opposition with senior counsel status, be it by anyone else, including the member for Oropuch East here today, is you can still apply for bail. Even if you are found in possession of an automatic firearm and a hand grenade, you can still go to a judge in the High Court and make your application for bail. So again, the whole rug is pulled out from underneath that argument. You're not being denied the right to bail. This is not like what happened between 2011 and 2014, when they ousted the court's jurisdiction completely. They ousted the court's jurisdiction completely for a handgun, a sidearm. We are here today. First offense, no prior conviction, nothing, no bail. We are providing here that you can go to the High Court for bail. The reality of the situation, and they know in caucus, they know what we're going to come and say. Well, I want to remind the people of Trinidad and Tobago why it is so important for us to be here today, Madam Speaker, passing this legislation to protect every law-abiding citizen in Trinidad and Tobago from those persons out there who have access to automatic firearms and grenades and the like. And there can be no legitimate argument, no legitimate response for anybody, not even a police officer, not even a member of the Trinidad and Tobago Defense Force, walks around with more than one automatic firearm. But we're picking up people with nine in their possession. And the ridiculous example of you go to the market, you're sitting down in a vehicle, and they pull over the vehicle, and the man run out into the bush and leave you there. Go to the judge in the High Court and tell him those are the circumstances. So are you not putting any faith whatsoever in the judiciary? Well, we on this side believe that in those circumstances, the High Court would do the right thing. And as the point that was made, it is not absolute a right to bail. It is still in the discretion of the court. But we need to make it harder for the criminal element to continue terrorizing us law-abiding citizens in Trinidad and Tobago. Trinidad and Tobago Police Service crime statistics, dated the 25th of November, that's Monday of this week. This is presented by the Commissioner of Police, and as the Minister of National Security, I get a copy. So if anybody else inside this house has it, I'll have some questions to ask.
You say you have it.
Yeah, you have everything, and I'll explain why in a short while. I want the people of Trinidad and Tobago to know, as at the 1st of January 2019 to today, the 27th of November, coming to the end of the year 2019, unfortunately, as at the time I came into this chamber, even though these statistics are at Monday, the murder toll, the homicide number from the 1st of January to the 25th was 480. Last night, another life was lost in very tragic, disturbing circumstances in the Port of Spain General Hospital. But no, the person who committed that heinous act, putting many lives at risk in a place where they've gone to recuperate, according to those on the other side, should be allowed back out on bail.
Yes.
They have no problem with that.
Do it again.
Go and do it again. Because we're protecting. Listen, this law, Madam Speaker, to put it in context, because there is an attempt to pretend to be the champions of justice for the poor and downtrodden. I want the population of Trinidad and Tobago to understand the fallacy of that argument, how misleading it is, and that it is a figment of some imagination. This law applies to persons caught with automatic firearms and grenades. Full stop. In possession of. And as I said, you could still go to the High Court and apply for bail. As of today, coming into this chamber, the murder toll for the year stands at 480. There are 4 divisions that have given us concern throughout the course of this year. The Port of Spain division, up. The Western division, up. The Northern division, up. And the Northeastern division, up. I do not think that that is a coincidence. I do not think that those are the divisions that are facing upsurges in the levels of criminality and crime with the use of firearms. And I have here with me today reports and documents from the police service and the intelligence services of Trinidad and Tobago that tell a very disturbing story. A very disturbing story about certain persons who are no longer in the chamber, who may not have come to the chamber, who sit in the other chamber, and these types of things. Very disturbing. So I point out now to the people of Trinidad and Tobago, look at these divisions. I then say, and this is provided by the Trinidad and Tobago Police Service, these are the statistics. This is the reality of what we're facing. This is not about old talk. This is not about emotion. These are pure data and pure facts. For the year, for the people of Trinidad and Tobago to understand that as of Monday of this week, the police service have taken off of the street for this year alone 735 illegal firearms. 700, and they will continue to take them off. Last year, by this time, it was 897. We believe we're finally seeing that trend of there's still an availability of illegal firearms, but not as much as before. For the year, we have taken 10,305 rounds off of the street. That's all that we've taken, 10,305. The same time last year, Madam Speaker, 15,556 rounds. Any sensible person will know when you're talking over 10,000 rounds, that is enough to go to a small war with. Marry that to the automatic firearms that we're talking about. And this is only what we've found and confiscated. This wouldn't include every single shooting now you have with the gangs. It's not 1 or 2 shots, you know. They spray and pray. And God forbid it is any of us inside of here, or anybody we know, any family member, any constituents, any law-abiding citizen. And it is their rights we've come here today to protect. Because nobody, Madam Speaker, in possession of an automatic firearm should be permitted the right to bail. What is this thing about? Is your first offense or a previous conviction? I'll come to why that doesn't apply. But you're going to give somebody who had 9 AR-15s the opportunity. So I'll catch you today with automatic firearms, but go back outside now. And let me see, be a good boy. Anybody in possession of an automatic firearm is not going to change overnight and become a good boy. Put them back on the street. Madam Speaker, I think the point is often lost, and I'd like to hear the response to this from any single person in the chamber, be it on this side or the other side. What is the reason to be carrying a firearm, an illegal firearm in the first place? A person who is carrying an illegal firearm is carrying it with the intent to kill somebody. It is not necessarily, if you have an illegal firearm, if even you make the argument it is to protect yourself, you are faced with a circumstance where you think you're going to protect yourself, you're going to kill the person you think is attacking you.
Yes.
So that is a fallacious argument. But even if, I give you the benefit of the doubt, carry a handgun illegally to protect yourself. You're going to walk around with a machine gun to protect yourself and a grenade. There is no one that can stand up with any sense of decency or any sense of sensibility and say that a person should carry an illegal automatic firearm. Not even a firearm user license holder could get the right to carry an automatic firearm. You cannot get the right from the Commissioner of Police to carry an automatic firearm. Not every police officer can carry an automatic firearm. And Madam Speaker, we go on. Murders by motive, right? So out of the 480 murders as of Monday, 86 were unknown, 148 definitely gang-related, 60 revenge, 53 drugs. I added the 53, the 60, and the 148 because to me, that is all gang-related and the criminal elements. 261 out of 480 by that sector, the same sector. And I'll tell you all why, through you, Madam Speaker. You can no longer say, in this day and age, the person should have a first offense or previous conviction. Because the statistics and the evidence are now showing that they're changing the persons carrying the firearms. They're ensuring that the persons carrying these automatic firearms from point A to point B for the criminal gangs, they're using younger people and they're using people who have no previous conviction for exactly this reason. And that is another reason why the Trinidad and Tobago Police Service has asked us the Trinidad and Tobago Police Service has asked us for this particular amendment. This particular amendment, Madam Speaker, is for that phenomenon. That you can't say the person must have a previous conviction. And look at the live example. The person caught with 9 AR-15s didn't have a previous conviction. You think that is by choice? You think that is by coincidence? But that's the whole point. Why you would even have one automatic firearm, one machine gun? And it trivializing, oh, don't tell me about Uzi and don't tell me about machine gun. I know about submachine gun. But what we will be saying, or what certain persons are saying, because we're certainly not saying it on this side, is, you know what, it's fine, you know. You're not previously convicted or charged for carrying AR-15s. Go back outside. We're giving you a chance. Go and take a walk. Go and get another 8 and come back. We are rejecting that. And we are rejecting that based on evidence. Another frightening statistic. Total murders, woundings, and shootings for the year as of Monday. So not only murders now, but also woundings and shootings, Madam Speaker. From the 1st of January to the 25th of November this year, 1,121 murders, woundings, and shootings occurred. 79.4 or 381 of the murders alone were committed with firearms. So 80% of the murders committed in Trinidad for the year are through use of firearms. And about 99% through the use of illegal firearms. That is the reality of what we are facing. So if we are facing that 80% of the murders in this country are committed through the use of illegal firearms, how could we with any conscience, whether the jokes are made about staring in the mirror at yourself or not, how can we with any conscience, the one duty, the one job we all have, the 41 of us here in this house today, to pass legislation, could say that a person with a hand grenade, a bomb, artillery, or an automatic firearm should be allowed bail on the first instance, or have the ability to get bail? We say the opposite. We say no bail for 128 days. You don't have to have a prior conviction, because we're not going to give you the chance to go back out there and commit the murder with an automatic weapon. And that is our position. And a position that is defendable. It infringes on no person's right. You cannot not pass law for the fear that one innocent person or two innocent people may be affected. Then don't have speeding laws, right? You want to talk about laws for setup? A police officer could pull any one of us over and say you're above the speeding limit. And there is nothing that you could do to prevent that. But you now must go and face the court and all of the trauma affected with it. So we wouldn't pass a law to deal with speeding because you were framed for it. Madam Speaker, comparative wounding and shooting with firearms by divisions from the 1st of January to November 25th. In 2018, there were 501 woundings and shootings, whilst in 2019, unfortunately, it's gone up to 641. We are working tirelessly and with all efforts, all hands on deck, and all the law enforcement officers are asking is for the legislators to pass this piece of legislation because they do not want to have to face a person who had no previous conviction, no previous charge, pointing those automatic firearms at them, because that is what is happening. That is how the gangs are operating. Every single one of these sophisticated gangs have access to these weapons. And we're fighting it, and we're meeting with some success. But still, Madam Speaker, they need the assistance. We need to be able to keep these persons off of the street. And these are criminals, because as I say, there can be no legitimate reason to have an automatic firearm in your possession. That is a simple premise. Weapons used in the commission of murders, another important statistic. So out of the 480 murders,
the original time is now expired. You're entitled to 15 more minutes to complete your presentation.
Thank you very much, Madam Speaker. So, Madam Speaker, out of the 480 murders committed for the year as of Monday, 381 were committed using firearms. Let that sink in. 381 murders out of the 480 were committed using firearms, 47 with sharp instruments. Therefore, firearms were used to commit 79.4% of the murders, followed by sharp instruments of 9.1%. Woundings with firearms and other weapons and shooting with firearms for the year, 599, compared to 656 last year. Possession of firearm and ammunition. Last year at this time, 1,153. This year, 935. So that shows that the hard work is bearing some success because both have gone down. Persons arrested. Persons arrested from the 1st of January to the 23rd of November 2019 for murder, 59. For wounding and shooting, 184. For possession of firearm and ammunition, 1,138 persons. So, Madam Speaker, to me that figure is startling. That for the year, the police have arrested and charged. So not just arrested, as my friend from St. Augustine would be able to point out the difference. Arrested and charged for the year for possession of firearms and ammunition, 1,138. So 1,138 persons arrested and charged for being in possession of an illegal firearm. That is very frightening as far as I'm concerned. These are some of the statistics, Madam Speaker, that go towards putting this bill in a contextual reality. Not the old talk, not the speaking of hypothetics, but the reality of what is being faced. Just quickly, Madam Speaker, to describe the bail process. So you're charged, you go before the court, you ask the magistrate to be granted bail, which means to allow you out and you have your liberty until the trial and your sentencing, your conviction and sentencing. That is what we're describing. And all this bill is saying is for anybody in possession of artillery, an automatic firearm, a weapon of war, yes, a weapon of war, a hand grenade, a bomb, or a device, other like missile, You have no access to bail for 120 days. But the two safety provisions, the police must start the case against you within that 120 days. So it is putting them in a tight time frame. And if you think you can, or you want to, you can appeal to a judge in high court. All of your rights are protected. But let us remember whose rights it is we are protecting. People found in possession of automatic firearms, grenades, and the like type devices. We introduced in August, for the first time, the offense of trafficking in firearms. And yes, we say this should also be caught by this legislation. Because anyone found in possession of 8 AR-15s, 9 AR-15s, we say more than 2 weapons, you're trafficking. So it is not true to say that this legislation provides no bail, as was suggested. First fallacy. It is also not correct to say that, as he put it, the Plummer case, the member for Urupuch East put it, the Plummer case, it would not have changed anything. Completely untrue. Because if the police had the ability to have charged under this provision, it would have caught those specific circumstances. Yes, we've explained why we're changing our policy with respect to trafficking in firearms and automatic firearms. I say it is nonsensical to use an excuse or to avoid passing law on the basis of there can be fabrication of evidence and framing. No one wants that. Every single criminal offense, including murder, can fall prey to that. We don't legislate on the basis that someone can be framed by the passage of the act. And as I say, in this specific piece of legislation we're asking, you can still apply to a judge in the High Court for bail. So it is not that you have no access to bail. I also found it ironic, Madam Speaker, when there was conversation about how much money we have to pay on a yearly basis, an annual basis, for persons who've been charged and malicious prosecution, etc. Because the example that came speedily to the front of my mind was the state of emergency, and that the taxpayers continue to pay tens of millions of dollars for a state of emergency that was unjustified. Madam Speaker, a short while ago, at the beginning of my contribution, I drew reference to what I found a disturbing trend, that in certain divisions, the Western Division, the Port of Spain Division, the Northeastern Division, and the Northern Division, we saw spikes in crime. As the Minister of National Security, one of the burdens that you carry is that you receive reports. And I always laugh when any reference is drawn to these reports. Take it to the police. These reports, on some occasions, come from the police. And the police are letting the Minister of National Security, and on many occasions, the chairman of the National Security Council, know what is taking place in Trinidad, because you need to know so you're able to govern better. I have in my possession, I've only brought 3 of them here today, but they are the most disturbing types reports that any Minister of National Security could read. The first one involves an incident at the Hyatt Regency Hotel this month by a member of this House. There was an incident at the Hyatt Regency during a sitting of Parliament where persons who are known to be involved in criminal activity began to have a stir and an outbreak at the Hyatt. And the Hyatt security called the police, and they called a certain member. And the reason they called that member, Madam Speaker, is because the criminals said they were here to meet the member. And when the member turned up there, he ended up paying the bill for the drinks. That's right. And then said, you were supposed to meet me. Stories right here in a special branch report provided. Thank you very much. I expect that from Naparima. I don't make up anything. Madam Speaker, and the proof is in the pudding. Very disturbing, because what it went on to say is that the member admitted that he was supposed to meet them. And then the further evidence that the police gathered is on many prior occasions, this was used as a meeting point.
Madam Speaker, I rise on 48.6. The member is imputing improper motives. He said the person is in the house. It could be all 16 or 18 of us. So on that basis, I start on 48.1, relevance of the speech, and 48.6.
Right.
Motives against any one of us here. We are in opposition. We are members of the House. So he might be referring to anyone. And we are not in that whatsoever. We are not in that whatsoever. It's a carte blasting, and that is not acceptable. I ask for it to be retracted.
Firstly, any member is entitled to stand under standing order and raise an objection. And I'd hope we'll all tolerate that. Secondly, I overrule the objection. It cannot apply to all, I can't remember how many numbers he said, because the member referred to a member. Please.
I want to say that.
Wait, what standing order are you on?
Member, I am. Member for. Now, I know in recent times we've been in many places. Many of you all here have been in all kinds of places where different rules apply. All right? But please don't sit there and challenge me. I'm not having a conversation with you, member. All right? I am cautioning all members to remember where we are and the rules which apply here. Member for Caroni East, you raised a standing order. I overruled. You have reminded this House repeatedly of your seniority. And again, and this is the last time, member for Caroni East, I'm going to caution you. Okay? And I'm cautioning all members. We are out in other places where other rules apply. Please remember where you all are.
Thank you very much, Madam Speaker. Madam Speaker, I saw it fit to draw some of this to the population's attention because I sat and I wondered, why would anyone who is a right-thinking citizen or civic-minded citizen object to a person who's found in possession of an automatic firearm or grenade? Why would anyone object to those persons being kept in prison for 120 days? And it dawned on me that we all have constituencies. We may all have constituents. Sometimes constituents don't know electoral boundaries or have the parameters of Parliament, but you have other types of constituents that you need to please. Some of the other reports talk about disturbing conversations between a sitting member, not here, and persons behind prison walls about strategy for local government. This report in particular talks about meetings with a notorious gang leader and the promise of contracts estimated at $14 million after the upcoming elections. They're also, not on the PNM side, there are also other matters that have come to attention on activities taking place on the East-West corridor. My fear is that a possible reason to resist this type of legislation that is so narrow and so focused on preventing criminals from being in possession of automatic firearms may be determined by constituents, and I don't use it in the electoral sense, who there's a need to associate with and to please outside of the legitimate citizens of and lawful citizens of Trinidad and Tobago. And I leave it right there. Madam Speaker, I end and I conclude by saying to the 41 members of the House that this piece of legislation is requested by the Trinidad and Tobago Police Service to assist them in their fight against crime, and to say that they are not meeting success and utilizing the pieces of legislation being passed is also a fallacy and misinformation. And I plead with all members to support this, because there can be no justifiable reason for amendment or to oppose it in its current form. Thank you very much, Madam Speaker.
Member for Laventille West.
Madam Speaker. Yeah, thank you very much, Madam Speaker. The Speaker recognized me. Thank you very much. Madam Speaker, I enter this very important debate, admittedly, Madam Speaker, in a mood that was affected by the presentation of the Minister of National Security in Trinidad and Tobago. Madam Speaker, we would have heard from the Attorney General the very simple terms and the framework in which this legislation is set. Madam Speaker, one of the big issues that have been raised is the question of the possibility of framing. The objection that is coming from the opposition is that this legislation will permit the possibility of the police framing individuals in accordance with this law. It has been made, the point has been made, and now I reinforce it, that a police officer has tremendous powers under the Police Act, and that he or she can, if he or she decides not to act in accordance with the laws, can certainly, and there have been examples of abuses of such authority and such power. Murder, Madam Speaker, is a capital offense, and persons have claimed, persons have been exonerated, and it is obvious that persons can be framed, whether in this jurisdiction or in other jurisdiction. It has happened for the capital offense of murder, which carries no bail. A person could be framed for a marijuana offense, obscene language, any offense. So the issue of framing is not germane to this. It is not specific, to this measure. It is of general application and possibility. So I cannot accept it as an argument against the provisions of the measures before us. It is not specific to these amendments, Madam Speaker, and has been alluded to, as has been alluded to before. Due process is a critical protective measure for the citizen in this matter and similar matters of criminal law. The Sunset Clause is a way that we treat with this question. We review the law after the sunset period would have expired, and we have had that experience in here again. There's the possibility of appeal. If a man is convicted and he was framed, and at first instance, or the magistrate found that he was guilty, he has the right to appeal, to deal with that. As well, Madam Speaker, and long before the appeal process, and that appeal process could take us even to the Privy Council outside of Trinidad and Tobago, notwithstanding the fact that it is our highest court of appeal. And in this legislation, both sides, both the prosecution and the defense, have the right to appeal if either side is aggrieved by the decision of the court. And long before that, Madam Speaker, I was a police officer. And while the member for Oropouche East tells us that there are rogue police officers, and no one would doubt that, the history of the Trinidad and Tobago Police Service, of the Jamaican Police Service, of the UK Police Forces, of the United States Police Services or Forces, it is well known. There will be and there have been rogue elements. But that admission suggests that it is an element, and that does not necessarily mean all are like that. So if a man has been arrested and is being framed, the first issue is the framing officer has to confront his peers. When he takes this man to the police precincts or station, he will have to explain to his immediate seniors, the second division officers, SDOs, why this man has been arrested, and there are procedures that they have to follow. So it's not just somebody decide to frame somebody. He'll have to get past his peers on the first instance. He'll have to get past his corporals and sergeants and inspectors of the second division, the SDOs. And then the way things go in the police service, as a former police officer, I would know, they then carry this file with all of the statements and the charges and everything to their senior officers in the division, who review it and then decide whether they should continue or otherwise. So within the police service itself, and police officers have arrested and charged police officers for every possible crime known to us in Trinidad and Tobago, including murder. In fact, it is the police, whether it is the Professional Standards Bureau or whether it is regular police. Police have investigated corrupt police and have charged them, and many have gone to jail on the basis of that. So within the very police service that they suggest could frame someone, there are some mechanisms to deal with that. And then in many cases, for serious offenses of this nature, the likes of these that we are dealing with in this law, they seek the advice of the Director of Public Prosecutions, exercising his authority under Section 90 and 91 of our Constitution, independent as he is. Independent as he is. Madam Speaker. And if, as has happened many times before, the DPP finds anything uncanny, untoward, insufficient in the evidence, deficient in the evidence, or legally problematic, he will send them back with it. That is another tier of protection. And I'm dealing with this question of framing, as though some officer could just walk up, charge a man with a hand grenade, or some automatic weapon, and that's the be-all and end-all of it. Of course. Of course. And then, in the way our system goes, Madam Speaker, and I know of a case, personally was involved some years ago when I was in national security, where a police officer, in fact, acted quite abusively. And the DPP got personally involved. A family, an entire family, including an elderly lady, I think about 87 years old, were arrested for something that was found in their backyard. And we got the facts. Because other police were paying attention to what was happening, because there was advanced information. And the family got charged. And the DPP, Mr. Henderson, as he then was, got involved in the matter and entered a nollie-pros immediately. So there are mechanisms for protecting against this big concern about framing. And in the way our system goes, more often than not, and with the legal aid system in attendance, the accused or the defendant or the suspect at the police station has advice from some lawyer. Lawyers will come in at the level of the police station to get an interview with their client, what is happening, speak to the police, speak to the client, and then the lawyer. So the lawyer is very early involved in protection of his client, even before the man is charged sometimes. And of course, once you get into the courts, The magistrate look cursorily at the evidence, look at the documents, whether it is in a preliminary inquiry. And as we move into the more modern system, having abolished the preliminary inquiries, there must be sufficiency hearings. And if the evidence is sufficient or legally deficient, at that stage, something happens. And of course, if it gets to the stage of the trial, as I said earlier, you have appeals all the way up to the Privy Council in some cases. And while all of that is happening, the citizen has constitutional rights, which this Parliament would have authorized and upheld as the law, the Constitution of Trinidad and Tobago, and they can seek redress in constitutional terms in the Constitutional Court if something went awry. So there are a whole host of protections, Madam Speaker, and on that basis, I consider, especially on the basis that framing is not specific to what is in front of us today, I contend that it really is of general application and possibility, and there are 1,000 ways in which we redress that in Trinidad and Tobago. And then you have the Police Complaints Authority. The citizen, even if he's incarcerated, can complain to the Professional Standards Bureau, complain to the Police Complaints Authority, and have persons investigate his concern or his claim against the framing officer. I have confidence in our system. No legal system is perfect. None could be like democracy, never perfect. After all, it throws up all kinds of people. Democracy. People with horrific records in public life. And of course, in conclusion on this point, Madam Speaker, within recent times, the Minister of National Security, the Attorney General, yours truly and others on this side, we promoted legislation protecting the citizens against the whims and fancies and abuse of prison officer, custom officer, immigration officer, and police officer, and fire officers. We have arranged in the anti-gang law, there are a host of offenses and recent laws we passed which suggests clearly to police officers, if you act outside of the law, very serious sanctions will be brought upon you. And that is where we are in Trinidad and Tobago. Not the least, the recent Miscellaneous Provisions Law Enforcement Bill, now perhaps an act, in Trinidad and Tobago. So I reject, you joined with us, Mr. Member for Carinese, very kind of you. So then I don't know, it is as if you swallow an elephant and strain it on a peanut. What we're doing today is no different to what we have done before. In fact, no different to what you have done. Because you passed anti-gang law in this country with our support that would have denied people's bail on a first offense, as we are trying to do today. So when the member for Oropouche is hypocritically asking us, why have we changed our policy between June and November? We have to ask you, why have you changed your policy from 2011 to today? What is the issue with first-time offenders? So that's the question we have to ask you. We are not persuaded by your fallacious arguments. We came here in Act 17 of 2019, and we said in respect of the Schedule 2 offenses, because, Madam Speaker, all we are doing as we proceed is responding to the sociological and criminal circumstances that we face in Trinidad and Tobago. As the criminals step up the game, the Parliament on behalf of the people must step up our game. And that's why we have been amending laws, and they appear to be becoming harsher, because the criminals are behaving more emboldened and more criminal by the hour. And the society has to respond to it. And that's the reason why we find ourselves amending laws like this as we go along. Because there's a culture in Trinidad and Tobago, and we have to react to the culture, Madam Speaker. So we came in that Act, 17 of 2019, and we said in terms of the very serious offenses in Schedule 2, and we all know them, I don't have to waste our time, but they include offenses under the anti-gang law, anti-kidnapping, trafficking in persons, those kinds of serious offenses, we say, if you had a conviction for one, and you are now charged with a similar Schedule 2 offense, you'll be denied the bail. And if you had a pending charge, and you found yourself with another charge for firearms, you will be denied bail. And if you were charged with a serious or Schedule 2 offense, and you are now charged with another one, you will be denied bail. All sensible and all very reasonable. That's what we said. And since then, Madam Speaker, we amended the Firearms Act to create new offenses because we realized that instead of having one handgun, a person could be found with 9, 2, 3. And just like a certain amount of marijuana before decriminalization, over 1,000 grams, it was perceived that you had it not for personal consumption. Right now in the decriminalization effort, we are looking at personal use or having in your possession 30 grams. When I saw 30 grams of marijuana last week, I said there's a lot of marijuana. There's about 60 spliff. If a man smoke all of that, well, Bob Marley ain't want nothing with him. He making song. Madam Speaker, but we're doing that and for good reason. But the personal 30 grams. But if you had 1,000 grams in the old traditional context of the Dangerous Drugs Act of 1994, if you had over 1,000 grams, you would have had it and you would be charged for possession for the purpose of trafficking because of the amount. And similarly, we said in this that if we amended the Firearms Act, if you are caught with more than one firearm, illegal as it already is, you will be deemed to have the extra ones for the purpose, or the firearms for the purpose of trafficking. Sensible and deterrent to those who might ordinarily use them or carry them around. And then we said, prohibited weapons, as the Minister of National Security pointed out, that's a special class of weapons inside of the Firearms Act, and it was always there, and that includes automatic firearms. And the minister pointed out, even when you apply as a businessman to the Commissioner of Police for a firearm user's license, you cannot get an automatic firearm. You'll get a semi-automatic pistol or something like that. You won't get an AR-15 because that is a military weapon of war, not expected to be used in a civilized, civil context or circumstance. But the criminals now will get automatic firearms. And you know, we have seen over the last 25 years, the police service, that civil organization, which got its tradition from the British police back in the day. Today they are more militarized. You hardly see blue and gray with pants, long pants anymore. It's operational wear with heavy arms, extra magazines. That is a reflection of the way the society is transforming at the hands of criminals. So if a police went with a pistol, a firearm, in a sack like long time down on the leg here, and he meet two AR-15s, it's trouble. So the police know that. And since they have to protect us, they must first protect themselves. So we see an escalation in this situation. And we said that these prohibited weapons, automatic weapons, hand grenades, because now hand grenades are in the theater of conflict here now too, you know. Those are prohibited weapons. It was always so under the Firearms Act. And if you are charged for those, you will be denied the right to bail. That's what we said when we amended the Firearms Act. Member for Caroni East. That's what we said. And then we sought to amend the Bail Act because of the seriousness of those offenses to say you will be denied bail for 120 days if you are charged for those two new firearm offenses. That's what we are saying. And the Section 7A of the last amendment we did to the Bail Act still stands on all counts. In all circumstances, you still have the right to go to a judge and say, I want bail, and the judge will then decide whether you should have it or whether you should not. That security, that safety net is still available, Madam Speaker. And the hypocrisy of my friends, especially when a bill requires a special majority, as this one does, a 3/5 majority. They play that they are the biggest champion of everybody's rights. And I say play. Madam Speaker, the Attorney General told us in this Parliament one time, some time ago, that privacy as a right under Section 4 of the Constitution is not absolute. They went berserk over that. For weeks, they criticized the Attorney General. We will now know that while they were shouting loudly criticizing him, Cambridge Analytica was a reality in Trinidad and Tobago since 2010. I don't believe nothing. I don't believe nothing. Yeah, and even before 2010. I know the facts of this book is before us. Let me leave that book. Thank you. Thank you, Madam. Especially that book with a very difficult title. Madam Speaker, the UNC spent almost 5 years and 3 months in office with the benefit of the anti-gang law with our support. And in that anti-gang law, you would have been denied bail for a first-time offense under those new offenses in the anti-gang law. What is the difference? We supported it because we are always on this side acting the wider and the national public interest. We look beyond the faults and we see the greater need, faulty and imperfect as we know they are. We don't take them on. We know what is good for Trinidad and Tobago. And once it's good for Trinidad and Tobago, you're guaranteed to get the PNM support in opposition or in government. So what has changed? Why all of a sudden this idea, this principle, this concept of restricting bail for first-time offense, all of a sudden it is anathema to my friends on the other side? It is hypocrisy. And the difference is that they take the opportunity to create obstacles, and the Minister of National Security gave us a possibility as to why, and I can't rule it out. Can't rule it out. Because we lived through life sport. The COP lived through an internal election where Tuggery was involved in the internal election of the COP by a former PP government minister, who, by the way, we are told is still up and down the corridor, all in Carapo, everything, campaigning for the UNC today as we speak. As we speak. And another one is up and down in La Hoqueta meeting with gang leaders as we speak. And we could pretend that we don't know in this house, you know, the people on the ground out there, they know full well what is happening. And they know that the member for Laventil West is speaking the living truth. Madam Speaker, and when the Minister of National Security spoke about a number of gangsters at the Hyatt last week, I'm a member of the National Security Council, and it came to our attention. Came to our attention. Went and paid a bill. In the fellows' way, they were expecting a meeting with the member, and they ran up a bill in their excitability and in the freeness and the opportunity of the moment. And when challenged to pay, they didn't want to pay. They were waiting on someone who left where he was and went and paid the bill. That is in a special branch report. I don't know why the Minister of National Security didn't call the name. And if you want to provoke me, I will. Madam Speaker, the Minister of National Security was very effusive on the question of the AR-15 in particular. We have seen a plethora of those within recent times. A man could make a robbery with a single firearm, a semi-automatic pistol, but when we see the accumulation of weapons of war, assault weapons, weapons that have a range of 3,000 yards and fatal in 2, and using 5.56 ammunition and 7.62, we know we have a problem here. And the Parliament has a role to play. And the government has a role to play. So the government bring these measures and we bring it to the Parliament where they have to be discussed and distilled. And we hope to get the support to protect the people of Trinidad and Tobago. If we do, we say, thank you, God. If we don't, we say, the wiles of the devil, the beast. Madam Speaker. And the member for Orapooch, my lady.
Honourable members, it's now 4:30. We'll take the suspension now. We'll be back at 5 o'clock.